All please rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
The clerk of court will please call the matter at hand.
Called for today's oral arguments are the cases in GR number 2085-66, Greco Antonius Beda Belgica et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 2084-93, Social Justice Society President Samson S. Alcantara versus Honorable Franklin M. Drilon in his capacity as Senate President et al. UDK 14951, Pedrito M. Nepomuceno versus President Benigno Simeon C. Aquino III et al. Appearing as petitioners or counsels for petitioners are the following: Attorney Eduardo V. Bringas, Attorney Alfredo B. Molo III, Attorney Aldrich Fitz U.D., Attorney Edmund Jason G. Baranda, Attorney Nico B. Valderrama, Attorney Raymond Parsifal A. Fortune, Attorney Samson S. Alcantara, and appearing as counsel for public respondents are the following: Solicitor General Francis A. Chardilesa, Senior State Solicitor Florin T. Hilbay, Associate Solicitor Emerson S. Bañez, Associate Solicitor Maria Graciela D. Base, Associate Solicitor Maximo Paulino T. Season III, Attorney Melbourne Pana, and appearing as Senate Legal Counsel is Attorney Maria Valentina Santana Cruz. Appearing as amicus curiae is Commission on Audit Chairperson Maria Gracia M. Pulido Tan. To tackle the procedural issues 1, 2, and 3 is Attorney Eduardo Bringas. He will have 7.5 minutes to tackle on procedural issue number 4 and substantive issue number 1 on congressional pork barrel is Attorney Alfredo B. Molo III. He will have 11.5 minutes. And to tackle presidential pork barrel or the substantive issue in number 2 is Attorney Aldrich Fitz D. To make the closing remarks will be Attorney Samson Alcantara. He will have 3 minutes. That's all, Chief.
The Petitioner's Counsel will please remain standing. Respondents' Counsel, kindly take your seats. For Petitioner's Counsel, we have decided that the 4 lawyers who are allotted time to speak will go through all of their presentations successively, uninterrupted by the interpolations of the justices. After the 4 lawyers have finished, then the interpolation of the justices will begin, and the justice asking may call on any of the 4 to answer whatever question is going to be propounded. Okay. The first speaker may please approach the podium and proceed.
Good afternoon, Your Honors. In Lascona Land versus CIR, this Honorable Court, through Mr. Justice Diosdado Peralta, reiterated the time-honored principle that taxes are the lifeblood of the government and so should be collected without unnecessary hindrance. He stressed, however, the necessity of reconciling the apparently conflicting interests of the authorities and the taxpayers so that the real purpose of taxation, which is the promotion of common good, may be achieved. Justice, equity, and good governance therefore dictate that when taxpayers have complied with their obligation, it becomes incumbent upon the legislative and the executive branches to fulfill their undertaking, and taxpayers have the right to demand its proper and prompt compliance. The appropriation designated as pork barrel, whether presidential or congressional, is a sui generis. They may have a semblance of propriety, but in reality, their primordial purpose is to advance the political and or private interests of their proponents. In politics, everyone has his own agenda, and horse trading is a necessity for the advancement of their individual interests. When both legislative and executive branches of government are in unity to prioritize their mindset, a symbiotic relationship for the propagation of a self-interest is established at the expense of the common good. Taxes are the lifeblood of government, and pork barrel is the chronic leukemia, a life-threatening disease, directly affecting and destroying the blood cells. The Honorable Report on Pdaf from 2007 to 2009 is the result of the biopsy test. The prognosis is chances of survival for full recovery are good, provided that major operation to remove the pork barrel tumor is immediately performed on Juan de la Cruz. The first procedural issue is on the locus standi. Petitioners in these consolidated cases aver that they brought their respective petitions in their capacities as taxpayers and or citizens of the Philippines. In a nutshell, the instant petitions seek to declare the congressional and presidential pork barrels unconstitutional and to restrain permanently the further release of monies from their respective pork barrels. In the 2010 cases of Biraogo versus PTC and Lagman et al. Versus Executive Secretary, this Honorable Court ruled that it leans on the doctrine that the rule on standing in a matter of procedure can be relaxed for non-traditional plaintiffs like ordinary citizens, taxpayers, and legislators when the public interest so requires, such as when the matter is of transcendental importance, of overreaching significance to society, or of paramount public interest. The guidelines to determine if the issue is of transcendental importance are the character of the funds or other assets involved in this case. In this case, the funds, the pork barrel is a public fund. The presence of a clear case of disregard of a constitutional or statutory prohibition by the public respondent, agency, or instrumentality of government. Pork barrel violates the constitutional prescription against undue delegation of the legislative power, separation of powers, and the directive on accountability. And number 3, the lack of any other party with the more direct and specific interest in the questions being raised. Respondents here are both the legislative and the executive branch of government, and there is no other party other than a taxpayer or a citizen who can bring this case before the Honorable Court. The second issue would be the issue on judicial review as against policy. The main issue in the petitions is the constitutionality of the congressional and presidential pork barrel. The provision of Article 8, Section 1 of our Constitution is crystal clear. Judicial power includes the power to determine whether or not there has been grave abuse of discretion amounting to lack of or excess of jurisdiction on the part of any branch of instrumentality of the government. The Honorable Court stressed in the case of Infotech Foundation versus Comelec that there is grave abuse of discretion when an act is done contrary to the Constitution, law, or jurisprudence, or when it is executed whimsically, capriciously, or arbitrarily out of malice, ill will, or personal bias. The grounds relied upon by the petitioners in support of their claim of unconstitutionality are violations of the constitutional provisions such as the non-delegation of powers, separation of powers, principle of checks and balances, and accountability of public officers. There is nothing in all the petitions that claims or that dwells on the issue of the wisdom behind the promulgation or the enactment of the poor barrel provisions, nor does it, nor any of those petitions deal with the policy on pork barrel. When the issue involves a grave abuse of discretion, the question becomes justiciable. This is because the issue is one of legality and not of wisdom. The third issue would be the actual justiciable controversy. The issue of actual controversy relative to the pork barrel, specifically with regard to Pdaf, was resolved in the case of Lamp versus Secretary of Budget. In the said case, the Honorable Court ruled that the possibility of constitutional violations in the implementation of Pdaf surely involves the interplay of legal rights susceptible of judicial resolution. The petition complains of illegal disbursement of public funds derived from taxation, and this is sufficient reason to say that there indeed exists a definite, concrete, real, and substantial controversy before the court. In the three pending petitions, the petitioners allege violation of the Constitution and illegal disbursement of funds relative to the congressional pork barrel. In addition, the petition in GR number 208566 avers violation of the Constitution as regards the presidential pork barrel. Hence, there is actual controversy in the instant petition. The attempt of both the executive and legislative branches to downplay the issue of pork barrel by claiming that the proposed 2014 budget already deleted the Pdaf provision as a lump sum, and the supposed measures being undertaken by the executive branch, such as the prosecution of the suspected culprits behind the issue on pork barrel, do not render the issues in these cases moot and academic. In the case of David versus Macapagal Arroyo, this honorable court held that the moot and academic principle not being a magical formula that automatically dissuades courts in resolving a case, it will decide cases otherwise moot and academic if it finds that, first, there is a grave violation of the Constitution. Second, the situation is of exceptional character and paramount public interest. Third, the constitutional issue requires formulation of controlling principles to guide the bench, bar, and the public. And fourth, the case is capable of repetition. In the instant petitions, there is grave violation of the Constitution. The case is of paramount public interest. The constitutional issues raised requires the formulation of controlling principles for the guidance of the bench and the bar and the public, so that in the future, billions of money of a public fund will not be dissipated. And fourth, the case is capable of repetition, precisely because even if the provision on Pdaf under the 2014 budget is eliminated, there are certain ways around it. And that's all, Your Honor. Thank you.
Thank you, Attorney Bringas. Attorney Molo.
Honorable Chief Justice and the Associate Justices of the Supreme Court, good afternoon. I am Alfredo B. Molo III, and I will be discussing the last procedural issue, the precedents of Lamp and Philconsa, and all the substantial issues on Pdaf. We submit, Your Honors, that Philconsa and Lamp do not bar the present petitions because, one, they operate on a different state of facts, and two, the presumed conflict only arises if they are given an overbroad reading. It has been ruled that a statute valid at one time may have become void because of altered circumstances and changed conditions. Router v. Esteban. We submit that the present petitions do not operate under the same circumstances as Philconsa and LAMP. First, 17 years of collective national experience of executive and legislative experimentation constitute significant changes to the factual premise of Philconsa. The second circumstance is the COA report, Your Honors. The lack of a post-audit report by COA was used as a defense of Pdaf in a 2012 paper or study by a former Speaker of the House. Well, there is one now. Perhaps, if the court at the time of Philconsa had a COA report available, it would have ruled differently. The third circumstance, Your Honors, is the fact that in the past 17 years, our jurisprudence on post-enactment measures has evolved, especially with Abacada versus Purissima. Only an overbroad and blanket reading of Philconsa, with due respect, Your Honors, would justify the observation that it is a blanket approval of pork barrel. The approval of the CDF in Philconsa, we submit, was confined to an evaluation of the law's textual formulation and the court's recognition that it was, at that time, dealing with an, and I quote, innovative system. The court decided to give it a chance, and indeed, Philconsa was the court's first exercise of judicial restraint on this issue, restraint that is no longer justified under the circumstances. We also submit that Philconsa just recognizes the political reality that congressmen and senators give advice and recommend all the time. For instance, politicians issue recommendation letters whenever there's a judicial appointment. Philconsa simply stands for the proposition that this happens, but it will never taint the appointment power of the President as long as he retains what is important, the choice of who to appoint, and no legislator can choose for him. We submit that a similar space be given to LAMP. LAMP turned on the presumption of constitutionality and regularity of functions, coupled again with the exercise of restraint. Hence the court's observation that petitioners lacked convincing proof to take a deeper look. Like Philconsa, we submit that LAMP not be read too broadly as a blanket approval of Pdaf. Instead, as a nuanced exercise of deference and restraint. We submit that the COA report fills the gap identified in LAMP. Your Honors, I will now discuss the substantive issues assigned to me, namely the issues on Pdaf. The Pdaf violates separation of powers because it is a post-enactment measure that allows legislators to perform acts beyond the time the Constitution requires them to stop. The line that separates legislation from execution is that moment when a law comes into effect. The Constitution draws this line, the line on the sand that no leader, benign or evil, saint or sinner, may cross. The 2013 Pdaf and the 2014 NEP allows members of Congress to cross this line. It mentions the power of, and I quote, identification of projects and designation of beneficiaries. The word, I quote, preference in choosing projects is also used. Whose preference does it refer to? The legislator. On allocation, we see the following phrase, projects to be identified by each legislator. In realignment of funds, the concurrence of the legislator must be secured before the DBM can act, even before a cabinet secretary can perform realignment. Your Honors, these are not just recommendations. Jurisprudence tells us that a recommendation can be disregarded, meaning the recipient can impose his own choice. The Pdaf is not recommendatory because first, the GAA does not say so. Second, DBM Circular number 547, which is an act of contemporaneous construction, binds the government. Circular 547 affirms what the 2013 GAA states, that the DBM cannot substitute its own preference in place of that of the legislator. Third, the COA's report's findings affirms that this is not mere advisory power at work. For instance, Your Honors, 2.85 billion pesos worth of funds were issued while ignoring the DBM's rules, according to the report. Since the implementing agencies themselves also said they never endorsed any project, then whose choice triggered the spending of 2.85 billion? In another instance, suppliers identified by the legislator himself got all of 152.408 million pesos. The government insists that they canalize discretion through mechanisms like menus. But that is not the point. It is not a matter of limiting participation, it is a matter of eliminating it together. This is because the Honorable Court has held in Abacada versus Purissima, which was decided after Philconsa, and I quote, "From the moment the law becomes effective, any provision of law that empowers Congress or any of its members to play any role in the implementation or enforcement of the law violates principles of separation of powers and is thus unconstitutional," end quote. Abacada was a case that concerned the only instance where Congress may act even after a law was passed, oversight. If the Constitution, according to the Honorable Court, bars any role, even if exercised in the name of oversight, then the ban is even more pronounced in simple matters of appropriation. I move to our second argument, Your Honor, undue delegation. Even assuming Pdaf is a legislative function and not executive, it is still unconstitutional because it allows individual legislators to legislate on their own. The Constitution vests legislative power in Congress, not the House of Representatives, not the Senate. Legislative power, Your Honors, we are taught, can never be delegated. We only delegate rule-making powers. Even Congress itself cannot change the procedure for making laws. It must adhere to, I quote, "the finely wrought, single, and exhaustively deliberated procedure specified in the Constitution." More importantly, Article 6 itself commits the appropriation power to collective action by both chambers. Clearly, Your Honors, the power of the purse belongs to Congress, not to congressmen or senators. The 2013 GAAS provisions on Pdaf and the 2014 NEP clearly identify individual legislators as the actors. It's not Congress. DBM 47 Circular, DBM Circular 45547, again, reinforces this. Your Honors, I will now move to our third substantive argument on checks and balances. The Constitution envisions a budget process where the executive's proposal are scrutinized by a disinterested Congress. It is a classic example of ambition countering ambition. The pork barrel destroys this balance. Its original sin is giving each legislator a direct financial interest in the smooth, speedy passing of the yearly budget. On the other hand, uncooperative legislators face retaliation from the executive's power to time the release of their Pdaf. The recent privileged speech of one senator indicates that this is not just theory anymore. In turn, the executive's discretionary funds have been creatively fashioned with astonishing amounts. This year, the proposal is 449.95 billion. And the fact that legislators themselves seem surprised by this realization is a cause for worry. Pdaf also impairs constitutional checks on Congress itself. We are taught in law school that Congress is checked by two things: self-regulation by the ethics committees and re-election. Despite the COA report, despite the plunder complaints, there does not seem to be any single ethics committee proceeding right now. As for re-election, Pdaf proceeds provide the offender the same means to perpetuate access. DBM records themselves were used by a group to show that Pdaf spending is concentrated in vote-rich areas and bailiwicks. In addition, Pdaf impairs the power of impeachment. Recent political history shows that the chief executive has little to fear from impeachment with a pork barrel in place. On the flip side, we have also learned that the funds can be a useful tool to fuel impeachment. This is state capture, Your Honors. We are trapped in a vicious circle in which the key reform to break the gridlock is undermined by collusion. I move to the last topic, Your Honors, which is accountability. We are told that the new safeguards will work this time. They promise. We disagree. Based on paper, it should have been impossible to misuse the Pdaf in the first place. And yet, there's the COA report. The fallacy stems from the view that corruption is all about stealing money. It is not. It is about abuse of power. It is about ignoring functional responsibilities and of overstepping boundaries. This is why adding rules to canalize legislators will never work. because the pork barrel system is designed to privilege legislators. We have tons of administrative circulars from the DBM and other agencies, statutes, and even court decisions. The COA report is proof that none of these rules mattered. More rules simply means more rules to ignore next time. Or let's consider simply what the executive agencies ask. In 2012, our current DSWD secretary confessed in an interview that she had asked that the DSWD be removed as Pdaf conduit. Why? Because, and I quote her words, "We will be held accountable for many things we have no control of. I'm saying this at great risk." End quote. In the COA report, the National Livelihood Development Center pleaded for the same thing. Your Honors, when a cabinet secretary fears a system she cannot control, when there are other agencies begging to be removed as Pdaf conduits, to insist on fiction becomes delusion. Or perhaps you should take the insight of the person leading the fight against corruption, Ombudsman Carpio Morales. In an interview just last week, she said, and I quote, "No matter how many people we hold liable, no matter how many government officials we send to jail, if the system remains uncured, the vicious cycle of corruption will not stop. The ill-fated system itself will breed the next generation of corrupt leaders." End quote. In closing, Your Honors, we wish to stress that we do not pursue separation of powers as empty ideals. We plead that the branches be kept separate because the accumulation of power threatens us all. And when the accumulation involves billions of public funds, the danger is inescapable. Taxes are our lifeblood, and we are bleeding to the tune of billions per year, guaranteed under this system. This is precarious. A famous jurist said, "A nation cannot plunder its own treasury without putting its own constitution and its survival in peril." We submit, Your Honors.
Thank you, Attorney Molo. Attorney Baranda. Who is going to speak? Attorney D? Yes, Your Honor. Okay, Attorney D.
Good afternoon, Your Honors. The scope of the executive's power to expend public funds has always been regulated by Congress. Whether the use of the Malampaya funds and the President's social funds by the executive conforms to this fundamental principle of our system of government is the constitutional issue placed before the Honorable Court. I will first proceed to discuss the constitutional issues raised with respect to PD 910 relating to the Malampaya funds and PD 1869 relating to the President's social funds. Thereafter, I will confront the arguments of the public respondents with respect to the request for the partial lifting of the Honorable Court's TRO. The presidential decrees creating these two funds being challenged today are remnants of the martial law days, where the powers of the executive and legislative branches were concentrated in one man. As wielder of both powers, the executive branch under the subject laws is given unbridled discretion to determine for what purpose the funds are to be applied. Such system of government no longer exists. The present Constitution enumerates and delineates the role of the executive and the legislative branches with respect to appropriations. Congress passes law appropriating public funds, while the President spends the budget. The Malampaya funds and the President's social fund violate the constitutional provision that no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. The Constitution requires a positive act from Congress, the passing of a law to appropriate public funds. First, with respect to the Malampaya funds, the same is treated as an off-budget item. No law has been passed by the legislature appropriating the fund for payment. Neither did the executive branch include the same in the budget proposal that it is constitutionally mandated to submit to Congress. Second, with respect to the President's social fund, it is also treated as an off-budget item. Again, no law has been passed by Congress appropriating the fund for payment. Worse, The law delegates to the President the power to appropriate the proceeds to fund and finance infrastructure and social civic projects throughout the Philippines. Furthermore, the subject laws creating the Malampaya funds and the President's Social Fund violate the constitutional requirement that discretionary funds must be subject to guidelines prescribed by law, which must emanate from the legislature. The law creating the Malampaya funds does not lay down guidelines for their disbursement. It authorizes the President to use the funds for such other purposes as he may direct. Contrary to the assertions of the public respondents, the principle of ejusdem generis cannot be cited to qualify the general phrase such other purposes for three reasons. First, there's no enumeration of particular words of the same class, an element for the principle to apply. Second, the words energy, resource exploitation, and development is a class that is complete on its own. Hence, the general words should be construed to mean a class other than energy, resource exploitation, and development. Third, the general words are further qualified by the phrase as may be hereafter directed by the President, which shows that discretion is given to the President to determine other purposes for which the funds may be applied. In fact, the executive branch has interpreted the presidential decree as giving it wide discretion to spend the Malampaya funds for such purpose as the President directs. This is evident not only from the issuance of EO 848, but even from the way the executive branch applied the funds. In a press release made on July 5, 2010, Budget Secretary Florencio Abad confirmed the Malampaya funds have been used for such varied purposes as the Armed Forces Modernization Fund, the Philippine National Police, and the National Housing Authority, among others. The law creating the President's Social Fund likewise does not lay down guidelines for its use and disbursement. The words infrastructure and social civic projects are general and vague. It authorizes the President to determine what constitutes infrastructure and social civic projects without guidelines to limit his spending power. That the President has wide discretion is evident from the phrasing of the law, specifically, and I quote, as may be directed and authorized by the office of the President of the Philippines, end quote. This unbridled power by the executive to expend money without a corresponding law wreaks havoc to the constitutional framework on appropriations and its system of checks and balances. Even worse are the staggering amounts at the disposal of the executive. Our people cannot rely on good faith commitments made by the present administration that public funds are being used for the common good. Our only real assurance lies in a judicial pronouncement on the constitutional metes and bounds of the issue of appropriations, especially with respect to lump sum discretionary funds given to the executive. Going now to the request of public respondents to partially lift the Honorable Court's TRO, we respectfully submit that the same should be denied and that a full injunction against the unused Pdaf remain in effect until final resolution by the Honorable Court. The provisional remedy of a TRO is issued to protect the rights of the applicant suffering grave and irreparable injury due to the acts of the respondents. Out of the 24.7 billion allocated for the Pdaf under the 2013 GAA, only 11.6 billion have been released according to the Department of Budget and Management. Hence, approximately 13.19 billion remains to be released. Petitioners and even other taxpayers have a clear legal right to enjoin unlawful expenditure of such huge sums of public funds and prevent its dissipation. The state will suffer grave and irreparable injury if the TRO is lifted, as billions of pesos will be unconstitutionally dissipated if the remaining Pdaf is released. Further, the Solicitor General's plea to release the Pdaf to help the identified scholars and indigent patients is inconsistent with his admission that the President has already committed to withholding of the remaining funds. This means that the Pdaf, as a solution to these problems, is no longer on the table. Public respondents are not without power to act on the pleas of the scholars and indigent patients. Congress can pass a law, a Special Appropriations Act, to supplement the General Appropriations Act. The executive is authorized to augment items in the General Appropriations Act from savings. Local government units are authorized to pass supplemental budgets under the Local Government Code. How these problems will be addressed by the legislative or executive branches is a question of policy, but certainly it does not lie with the lifting of the Honorable Court's TRO. Petitioners are not insensitive to the needs of our countrymen who have relied on the Pdaf. Nevertheless, any public solution to alleviate their suffering must be derived from a process sanctioned under our democratic framework and not through any unconstitutional means. In Birauco versus the Philippine Truth Commission, the Honorable Court held, and I quote, "No matter how noble and worthy of admiration the purpose of an act, but if the means to be employed in accomplishing it is simply irreconcilable with constitutional parameters, then it cannot still be allowed." End quote. One cannot help but sympathize with the plight of those who have relied on the Pdaf for their educational and health needs. Indeed, the pork barrel system may have become so ingrained in the national consciousness that some of us may have learned to forgive the excesses of congressional largesse for as long as they can depend on elected officials for dole-outs, for tuition fees, and hospital expenses. It is time that our country breaks away from this system of dependency, which has, contrary to its avowed purpose, not even significantly contributed to the development of the poorest regions of our nation. At this point in time, there is nothing more pressing than the abolition of this unconstitutional mechanism of a pork barrel system. In doing so, the Honorable Court shall help ensure the sanctity of properly appropriating national funds for the greater public good and not for any individual private gain. We submit, Your Honors.
Thank you, Attorney D. And Attorney Alcantara, you proceed, please.
Good afternoon, Your Honors. Petitioners Greco Belhica, Jose Villegas Jr., Jose L. Gonzalez, Reuben M. Abante, Quintin Paredes San Diego, Pedrito Nepomuceno, and yours truly, Your Honor, Samson Alcantara, wish to express their eternal gratitude to this honorable court for giving them the opportunity to present their arguments in support of their petitions. At the same time, they fervently hope that in the end, this honorable court will favorably act on their petitions to abolish a system that has nurtured the virus of corruption that has caused the Filipino people to lose trust in and respect for their public officials and consider them as thieves and marauders of the public treasury. In his speech in the APEC CEO summit last week, President Aquino admitted that our country has a long history of corruption. Petitioners are very confident that they have shown their legal standing to institute the present actions. Most certainly, as Filipino citizens and taxpayers, they have personal and substantial interest in challenging the constitutionality of a system permitting the misappropriation of billions of public funds derived from taxation or from the utilization of our natural resources. There can be also no doubt that the controversy now before this honorable court is definite, concrete, real, or substantial, considering that petitioners complain of illegal disbursement of billions of public funds. The controversy in the present cases is not merely one of policy, but of constitutionality. Petitioners do not question the authority of the political branches to solve or remedy the Pdaf problem, but such solution must be in accordance with the Constitution. Whatever decision this Honorable Court will render in these cases would not be in the nature of a judicial solution. It is an exercise of the judicial power, which is not only a power but a duty. As guardian of the Constitution, this Honorable Court has the duty to prevent the continuing injury to the fundamental law through the continued enforcement of an invalid law. Petitioners fully understand the extreme reluctance of this Honorable Court to digress from its previous decisions, but we earnestly urge this Court to consider the instant cases an exception. We hope you have shown facts and circumstances seriously warranting a re-examination of the Philconsa and LAMP cases. Petitioners hope that they have been able to convince this Honorable Court that the Pdaf, the BIL, the presidential pork barrel are unconstitutional. Your Honors, the Filipino people are obviously losing confidence in the political branches of their government. Public office has become one of public distrust. Their only hope now is with this Honorable Court, whose decision in these cases will without doubt reform our society, gradually restore the people's trust and faith in their public officials, do away finally with the culture of dependency and political patronage, and ensure the expenditure of all public funds only for public purposes. This Honorable Court will not only be regarded as a reformer, but a savior of this country. Thank you, Your Honor.
Justice Benabe will start the interpolations.
I'd like to call on Attorney Molo to answer some preliminary questions before I proceed to the procedural issues. Okay.
Good afternoon, Your Honor.
Good afternoon, Attorney Molo. One of your prayers is to declare the pork barrel system unconstitutional.
Yes, Your Honor.
Okay. In brief, what is the pork barrel system all about?
From the perspective of the petitioners, Your Honor, it is composed of two components. The first would be the legislature's Pdaf, and we identify it as a portion of pork barrel because it enables the legislature to, in an appropriation measure, act in any way, in any role, in any manner after that law has been passed. And the second would be the presidential pork barrel, which we identify by the fact that it violates the constitutional prescription that any discretionary lump sum fund of the President must be canalized with sufficient operative guidelines emanating from law.
So which departments of the government are involved in the system?
Your Honors, it would be the Department of Budget and Management, from which the proposals of the budget the yearly proposals of the NEP emanate from, and as well as the legislature, Your Honor.
So you're referring to the executive department and the
yes,
legislative
yes, Your Honor.
department. Now, what is the participation of the legislative department in the system?
Your Honors, their participation starts in Article 6, Section 25, and all of its provisions in Article 6, Section 26. They are the ones who scrutinize the national expenditure program after it has been submitted by the executive to them.
So, in short, it enacts the law,
Yes, Your Honor.
the appropriation law in particular.
Yes, Your Honor.
Okay, how about the executive department?
Your Honor, they are mandated to create the national expenditure program itself. And then afterwards, once the appropriation law has been passed and takes effect, they are the ones who execute appropriations.
Okay, what funds are included in the system?
Essentially, Your Honors, as presently worded, Your Honors, it would be the Pdaf as well as the various discretionary lump sum funds of the President, Your Honors.
And then?
as well as the various
The
executive.
Malampaya
Yes, Your
funds?
Honors.
What
And the
else?
Presidential Social Fund. And
And-
I believe there are, if I may refer to the petition, Your Honor. We identified several, Your Honor. I'll just take a time to locate that portion. It's
Are you referring to other lump sum
Yes, Your
discretionary
Honor.
funds? That includes the DAP.
yes, Your Honor. Right now, as it is
Disbursement
appearing to be, yes, Your
allocation
Honor. The budget
program.
within the budget, Your
Okay.
Honor.
Now, can you tell us what projects are funded by the Congressional Pork Barrel?
Your Honors, these would be the projects identified by the menu included in the Pdaf as worded in the 2013 GAA as well as in the 2014 NEP.
How about the Malampaya funds?
The Malampaya Fund, Your Honor, is supposed to be used solely for the energy utilization, development, and exploitation
And
purposes,
how
Your
about
Honor.
the President's Social Fund?
Among the stated purposes, Your Honor, would be, forgive me, Your Honor, the phrase escapes me, but the the power to appropriate the proceeds to fund and finance infrastructure and social-civic projects, Your Honor.
How about the other lump sum discretionary funds? What do they
That's,
fund?
sorry, Your Honor. That is the problem, Your Honor, that we encountered while analyzing the budget, Your Honor. It appears that there's a sliding scale. There's a vague, let's say, there's a vague standard, and you don't really know exactly what's being funded in some of the funds, Your Honor. Offhand, I encountered, for example, e-government fund. I'm not sure how specific the guideline will actually plan out to be. Some actually, Your Honors, in the NEP are new ones. And as we observe over the GAA for past, or the NEP for the past years, there seems to be new funds created, like the DAP.
Okay. Can you tell us specifically what laws cover each component? Like for the PDAF, what law is involved?
Your Honors, for the Pdaf, that would be the 2013 GAA itself, the subsections 2, 3, 4,
And other
entitled XLIV.
other appropriation laws containing PDAF.
Yes, Your Honors.
Okay. How about the Malampaya funds?
That would be PD 910 and PD PD 910, Your Honor, for Malampaya,
And the President's Social Fund.
which is thank you. The Presidential Decree number 1869, Your Honor.
All right. Can I now call on Attorney Bringas to answer questions on procedural issues?
Thank you, Your Honor.
On the procedural issue of whether or not petitioners have legal standing to sue, petitioners state that they are citizens and taxpayers.
Yes, Your Honor.
And as such, they have the legal standing to have the pork barrel system as well as the PDAF laws declared unconstitutional because they allow wastage and improper use of public funds.
Yes, Your Honor.
Now, the respondent did not raise any argument on this issue in their comment, so I will just proceed on the next procedural issue. Now, is it correct to say that petitioners are not questioning the wisdom of Congress behind the enactment of appropriation laws, but the manner by which these powers are exercised?
Yes, Your Honor.
Do you think the intention of respondents to replace PDAF with a defined program of line item budgeting constitutes enough justification for the court not to resolve the constitutionality of the pork barrel system?
With due respect, Your Honor, we believe that the issue should be resolved, the constitutionality of the matter should be resolved in order to prevent future instances of this matter that happened in the past. And also, Your Honor, we also are of the position that the matters are of such public interest. And there are instances that, as I enumerated earlier, which allows the Honorable Court to resolve an issue even if it is already moot and academic. And if I may go over again, Your Honor. And these are, Your Honor, that there is a grave violation of the Constitution, and these were alleged in the petition, Your Honor. And second would be the situation is of exceptional character and paramount public interest. Again, Your Honor, the issue on pork barrel is an exceptional character and a paramount public interest because it involves public funds that are being divested and being depleted. The constitutional issue requires formulation of controlling principles to guide the bench and the bar and the public. Again, Your Honor, we submit that the issue of pork barrel requires the formulation of controlling principles in order to prevent any future misuse again of these funds. And the last would be in case of it is capable of repetition. Your Honor, although there are already supposed measures to eliminate or remove Pdaf, the point is, for as long as there are measures that would, in effect, be in the nature of a pork barrel, then that would be, to our position, subject again to abuse, Your Honor.
But are you aware of the reforms instituted by the legislative department in the pork barrel system since 1990 up to the present?
Yes, Your Honor. But just Your Honor, these reforms did not deter the commission of anomalies, and in this case, Your Honor. And that's, in fact, that's the very reason why the 2007 and 2009 report of the Commission on Audit.
Can you tell us some of these reforms?
Yeah, let's just go over it, Your Honor. As early as 1990, when CDF was came about, the CDF was limited to supposedly aims to support the small local infrastructure and other priority community projects which are not included in the National Infrastructure Program involving massive and costly projects. Now, in the year 2000, and CDF was transformed into Pdaf. Now, there were reforms introduced, such as the congressional soft and hard projects, are definitely far departure from the original American system of pork barrel. But in this case, for example, in the 2008 General Appropriation Act, there's a provision that use and release of funds among appropriated herein shall be used to fund priority programs and projects under the 10-point legacy, age agenda of the national government, and shall be released directly to the implementing agencies as stated hereunder. And it provides also the pavements of construction and repairs, irrigation, peace and order, housing, forest management, and historical arts and culture. The innovative additional safeguards during those times stated that the House of Representatives has directed for further transparency and accountability the publication of a congressional website all of the project and programs identified by House members under their respective lists of soft and hard projects. So far, Your Honor, we have not seen the website.
So did these reforms cure the defects in the system?
No, Your Honor.
So you do not believe that the executive and legislative departments should first be given the opportunity to improve the system before the court interferes?
Yes, Your Honor, because in the first place, Your Honor, what we are asking is to declare the constitutionality of the existing law, which is the General Appropriation Act 2013. Now, any future reforms will be immaterial at this point because the provision of the law is existing now, and this is what we want to have declared unconstitutional. And for that purpose, Your Honor, we pray that guidelines will be provided by the Honorable Court so that in the future, things of this nature will not happen again.
Okay, let's go to the next procedural issue. In one of your pleadings, you argue that the COA report establishes that both the executive and legislative branches repeatedly abused their discretion in utilizing Pdaf. In effect, are you saying that the COA report indicates a pattern or scheme of misuse of the Pdaf in all the years that the Pdaf or any of its previous versions was in place?
We stick to the facts, Your Honor. What we stated is only exclusive to the years 2007 up to 2009.
So you are referring only to the years 2007 and 2009?
Yes, Your Honor. But the point, Your Honor, is that the tendency, the dangerous tendency of this being perpetrated from the start is already there. No? Although we, at this point, do not have the factual basis, but we can await for, again, report from the COA, Your Honor.
So do you believe that the misuse is already a pattern?
Yes, Your Honor.
Now, how about for the Malampaya funds and the President's Social Fund? Is there any COA report covering the use of these funds?
None at this moment. None that I know of, Your Honor.
Probably
at this point.
we can ask
Yes, Your Honor.
Ms. Grace,
Uh,
the COA auditor. Do you have reports on this?
Your Honors, yes, we have had audit reports on the Presidential Social Fund. This is included in the audit of the Office of the President. And so far as the Malampaya funds is concerned, we have had reports also, except that these were on an agency per agency basis. The agency to which Malampaya funds were released, the audit of our agency, our audit of that agency, that would be where we would include findings on the utilization by that particular agency of the Malampaya funds. We are, however, now doing an agency-wide consolidated audit of the Malampaya funds from the time from 2002 to 2011, Your Honors. So that is an audit that is it's ongoing.
But you have not released any report on this?
We have finished the portion on the Department of Agrarian Reform. We are finalizing it, Your Honor, and we will be releasing it shortly.
Will you
This
be able
is
to
the-
furnish this court with a COA report on this?
Certainly, Your Honor, we will do.
How soon would you be able to give us copies of this?
We are looking at a period of about a month for us to release the report, particularly on the 900 million that was given to the Department of Agrarian Reform.
How about for the President's Social Fund? Do you also have a report? Are you investigating on this?
We audit the Presidential Social Fund every year, Your Honor, and our findings are included in our audit report on the Office of the President. Maybe later I can discuss or present some of our audit highlights on the Presidential Social Fund.
Okay, thank you very much.
Thank you, Your Honor.
Okay, can we continue? Council, you have mentioned statements and articles regarding the utilization of Malampaya funds, that they were released to the PNP, to the Department of Agriculture, to the NHA, and to the DAR. Can you tell us the basis of your conclusion that they were misused?
May I beg that the issue would be discussed by our colleague, Your Honor, who handled the issue, Your Honor.
No, this is just on procedural issue. No.
Your Honor, with respect to the Malampaya funds, we base it from a press release made by the Department of Budget and Management. They indicated therein that the Malampaya funds were used in the previous administration to fund the Armed Forces Modernization Fund, the Department of Agriculture, the Department of Agrarian Reform, the DPWH, the NHA, the PNP, among others. The press release does not state that it was misused, but our position, Your Honor, is that the Malampaya funds constitute undue delegation of legislative power, considering that it authorizes the president to use the funds for such other purposes as he may direct or authorize.
Okay, and you believe that these statements and articles are sufficient proofs to show that there exists an actual and justiciable controversy with respect to these funds?
Your Honor, they are official acts made by a department under the executive branch, Your Honor. They may be taken judicial notice of, Your Honor.
Now, can you please attach to your memorandum copies of these articles? Or
we will, Your Honor.
Okay. Attorney Molo, can we now go to the substantive issues? Attorney Molo, can you please go over Special Provision 1 of the 2013 GAA provisions on Pdaf?
Yes, Your Honor. 2000. Purposes, Your Honor.
Okay.
Support for priority programs and projects, 7,657,000,000.
Okay. What does the first column provide?
Personal services, Your Honor, and then the second column is maintenance and operating.
No, under the programs and projects on Special Provision 1, you have the menu.
Yes, Your Honor.
Okay. The first column provides the classes of projects.
Yes, Your Honor.
Such as education, health, renovation of roads. Now, how about the second column?
It states the implementing agency, Your Honor.
Okay. And the third column states what?
The list of requirements, Your Honor.
Okay. Can you go over Special Provision 2? What does it state?
Project identification, Your Honor.
Okay. What is the process?
Your Honor, the process is that the identification of projects and or designation of beneficiaries shall conform to the priority list, standard or design prepared by each implementing agency. That preference shall be given to projects located in the 4th to 6th class municipalities or indigents identified under the NHTS PR by the DSWD. For this purpose, the implementing agency shall submit to Congress said priority list, standard or design within 90 days from effectivity of this act.
So under this provision, would you agree that when the implementing agency submits its priority list of projects to the legislators choose the specific project they want from the list?
Yes, Your Honor. They choose from a list.
So in the end, the individual legislators have the final say?
Yes, Your Honor. They make the choice.
Okay. Can you please go over Special Provision 3?
Special Provision 3, Your Honor, is legislators' allocation. The total amount of projects to be identified by legislators shall be as follows. For congressional districts or party list representatives, 30 million. For soft programs and projects listed under Item A, and 40 million for infrastructure projects listed under Item B. The purposes of which are in the project menu of Special Provision Number 1, and B, for senators, 100 million pesos for soft programs and projects listed under Item A, and 100 million pesos for infrastructure projects listed under Item B, the purposes of which are in the project menu of Special Provision Number 1, subject to the approved fiscal program for the year and applicable special provisions on the use and release of fund. Only 50% of the foregoing amounts may be released in the first semester, and the remaining 50% may be released in the second semester, Your Honor.
So here you have the limits of the allocation for each congressman and senator, correct?
Yes, Your Honor.
Now, under the first sentence of this provision, how is the term projects qualified?
Your Honor, it is qualified by the phrase, and I quote, "to be identified by legislators shall be as follows," end quote.
Now, does this qualification reinforce your previous stand that the legislators have the final say in identifying the projects?
Yes, Your Honor.
Now, please go over Special Provision 4. What does it say?
Your Honor, Special Provision Number 4 tackles realignment of funds. It says, realignment under this fund may only be allowed once. The Secretaries of Agriculture, Education, Energy, Interior and Local Government, Labor and Employment, Public Works and Highways, Social Welfare and Development, and Trade and Industry are also authorized to approve realignment from one project scope to another within the allotment received from this fund, subject to the following. 1. For infrastructure projects, realignment is within the same implementing unit and same project category as the original project. 2. Allotment released has not been obligated for the original project scope of work. And 3. The request is with the concurrence of the legislature concerned. The DBM must be informed in writing of any realignment within 5 calendar days from approval thereof, provided that any realignment under this fund shall be limited within the same classification of soft or hard projects listed under Special Provision 1 hereof, provided further that in cases of realignments, modifications, and revisions of projects to be implemented by LGUs, the LGUs concerned shall certify that the cash has not yet been disbursed and the funds have been deposited back to the BTR. Any realignment, modification, or revision of the project identification shall be submitted to the House Committee on Appropriations and the Senate Committee on Finance for favorable endorsement to the DBM or the implementing agency as the case may be.
Now, do you agree that under Special Provision 4, no realignment, modification, and revision of the project identification can be made without the favorable endorsement of Congress?
Definitely, Your Honor. In fact, it is very explicit that the concurrence of the legislator concerned must be secured, even if it's a cabinet secretary.
Now, under the first paragraph of the same provision, if the realignment is requested by the department secretaries, you need the concurrence of the concerned legislator. Is that
yes,
correct?
Your Honor.
Now, kindly go over Special Provision 5. What does it state?
Special Provision Number 5 states, Your Honor, release of funds. All requests for release of funds shall be supported by the documents prescribed under Special Provision Number 1 and favorably endorsed by the House Committee on Appropriations and the Senate Committee on Finance, as the case may be. Funds shall be released to the implementing agencies subject to the condition under Special Provision Number 1 and the limits prescribed under Special Provision Number 3.
Now, under Special Provision 5, can the funds be released without the endorsement of Congress?
No, Your Honor, because it relates to the previous Special Provisions 1 and 3.
So under all these provisions, do you think that the identification of the individual legislator is recommendatory or mandatory in nature?
Definitely not, Your Honor. And it is our position that...
It is mandatory or recommendatory?
It's mandatory, Your Honor.
It is mandatory.
Yes, Your Honor.
Now, can you therefore say that the individual legislator is exercising a legislative function because the act of identification is part of appropriation?
We would as an alternative argument, Your Honor, we would say that it is legislative and he is acting on his own.
Okay, but can an individual legislator alone exercise legislative power, considering that the Constitution vests such power in Congress as a body?
No, Your Honor, especially since this is appropriation and under the Constitution, Article 626 commits the same power to Congress alone.
And therefore, would you consider the individual legislator's act of identification to be valid?
No, Your Honor.
Now, without the recommendation of the individual legislator, which you said is mandatory, do you think the law has sufficient standards for its implementation?
On its own, Your Honor, the menu provides a detailed standard of what the projects will be funded, Your Honor.
Is that sufficient standard?
Well, Your Honor, the problem here with the Pdaf, Your Honor, is that it is left to the legislator himself to pick and choose. Precisely. So it actually divests the actual Appropriation Act to
Assuming
a single
there is no
legislator.
recommendation.
Assuming there is no yes, Your Honor, because
Only
it's
the menu of projects and the allocation appear in the appropriation law. Would there be sufficient standards for implementation?
I would argue, Your Honor, no, because we are giving them a lump sum item and then it's up to them, Your Honor, to pick and choose again.
Now, do you have the 2012 GAA?
Yes, Your Honor.
Okay, can you see provisions similar to special provisions 1 to 5 of the 2013 GAA?
I have a menu, Your Honor. Yes, Your Honor, it includes a menu and requirements and preference for poorer municipalities. It does have project identification, but it does not expressly designate them as hard or soft projects. There is no similar provision on projects outside the district. The amount of Pdaf is the same. The timing of the release is a similar provision. The realignment of Pdaf is similar to 2013. The procedure for release says that there's no provision requiring submission of necessary documents for release. But for the release of the implementing agencies and posting requirements, they are the same.
No, for the release of funds, is it required that the House Committee on Appropriations and Senate Committee on Finance make a favorable endorsement?
No, Your Honor.
Okay, can you go over the 2007 to 2009 GAAs, which are the years covered by the COA report? Do you see the same provisions?
Your Honor, there's a menu for 2007, 2008, 2009, but there's no list of requirements. The project identification, there is, but not expressly designated again. But for the realignment, no similar provisions, Your Honor. In the procedure for release, there's no similar provision.
But how come in the COA report, which covers the 2007, 2009 GAAs, there were findings that the legislators identified projects and that there were already allocated limits which are not found in the law?
Well, Your Honor, the lack of the similar stringent standards in the 2007, 2009, Your Honor, actually, to our mind, would actually reinforce our position that even if these are blanket and it doesn't even give textual power to a legislator to identify and concur and limit realignment and control release, they managed to do it in 2007 up to 2009, as evidenced by the COA report. So it's actually worse, Your Honor, during those years because there was not even an express grant that they could identify. And yet, the 2007-2009 GAAs were still used, according to the COA report, to identify and even control suppliers.
So are you saying that the participation of the legislators in the identification of the projects and release of funds has become an institutionalized practice?
Yes, definitely, Your Honor.
Okay, now on the next matter, under the doctrine of separation of powers, who makes the law?
Congress, Your Honor.
Who implements the law?
The executive.
And who interprets the law?
It is the Honorable Court, Your Honor.
So when does the power of Congress end?
The power of Congress end to make law the end of the power of Congress to make law is when the law takes effect.
Okay, but under the 2013 GAA and the other GAAs containing Pdaf and its previous versions, do you think that the legislators still played a role in the implementation of the law when
Yes.
they identified and specified the projects to be implemented and involved themselves in the realignment and release of funds?
Yes, Your Honor, definitely. They are playing an active role.
Do you think that when individual legislators identify projects, they are merely assisting the implementing agency in filling in the details of the law?
Well, there are two things problematic with that, Your Honor. First of all, it is not their job to assist executive agencies in execution because it is prohibited. They are not allowed to execute law. And second, even if they just claim to be doing so, they are participating a role after the law has come to pass or come to effect.
So if the individual legislators do not merely assist in the filling in of the details, what then are they doing? Are they effectively commanding the executive to follow their identifications?
Yes, Your Honors.
Now, under the COA report, do you think that the legislators merely assisted? I'm talking of the COA report now. Do you think that the legislators merely assisted the executive in the implementation of the law? Or did they actually take an active role in its implementation?
Well, Your Honor, under the COA report, based on my limited understanding of the fact, all the figures there, I would say that they were in control. For example, Your Honor, there's a finding that in some instances, the DBM's own measures were totally ignored to cause the release of 2.85 billion pesos. An implementing agency claimed that they were not even, they never endorsed a project at all. And yet you have, I think, 150 million pesos being released. So yes, Your Honor, under the COA report, they were in control, the legislators.
Now, what is your basis for saying that there was a violation of the doctrine of separation of powers? Is it just the COA report?
Well, no, Your Honor. It's the law itself as phrased, Your Honor, along with the DBM circular, which is a contemporaneous construction of the GAA, which binds the government. Both of these textually say that as you look at it, legislators are exercising an executive function.
And what is your basis also for saying that there was grave abuse of discretion on the part of the legislative and executive departments?
Your Honor, our basis for saying that there is grave abuse of discretion is because the law on itself, on its face, already allows them to perform something prohibited by the Constitution. And yet, as Your Honor walked us through, over the years, they continue to enact and repeat the same violation year in and year out. And it's a third prong, Your Honor, they benefit from it directly, as reflected by the COA report.
Okay. Now, on another matter, how does the legislative department check the executive department's power to spend funds from Pdaf?
It's supposed to be checked, Your Honor, when after the NEP has been passed to the executive branch, and they will evaluate the proposals of the DBM, the executive department.
Is congressional oversight one of the means to check public spending?
Yes, Your Honor.
But do you think this can be done effectively?
Under these standards and as the way that it has been phrased, no, Your Honor. How can it be done effectively when we have the power, the people who were supposed to watch over the coffers being charged under the COA report to be the ones who are actually taking something from it? It's a conflict of interest situation, Your Honor. The oversight power is now being exercised by financially interested individuals as proven by the COA report.
Now, on the issue of accountability, are the problems on accountability due to defects in the implementation of the law rather than the defects in the 2013 GAA itself?
Your Honors, the GAA and the DBM circular on its own, their text, it's defective and violates separation of powers. We merely listen to the wise words of the Honorable Court in LAMP. That's why we waited for this COA report, because we were guided by the words and the wisdom of this court that before a challenge on the constitutionality of an act, especially the GAA, we would have much more than just mere conjectures to support us. But it does not mean that we are alleging that it is just the COA report. It is the law itself, Your Honor.
Okay, I missed the procedural issue on res judicata and stare decisis, and I'm going to that issue right now. Now, what is the subject matter in the Philconsa case?
Your Honor, it was the presidential veto primarily exercised during that time by the
No,
President.
what is the subject matter? What GAA is involved?
That was the 1990 GAA, Your Honor.
1994?
I believe 1994, yeah.
1994. How about in the present petition? What is the subject matter?
It's the 2013 GAA and the 2014 NEP, Your Honor.
And other appropriation laws containing Pdaf.
Yes, Your Honor.
Now, under these circumstances, will res judicata apply?
It should not, Your Honor, strictly speaking, because they are different subject matters already, Your Honor.
Okay. Now, in Philconsa, it was ruled that members of Congress have the authority to propose and identify projects to be implemented by the executive, and that this authority is only recommendatory in nature. Correct?
Yes, Your Honor.
Now, if the exercise of such authority is part of the legislative process, would such authority be merely recommendatory, or does it become mandatory?
Your Honor, if it is part of the legislative process, it becomes mandatory, if construed that way.
Now, what about if the exercise of the same authority is part of the implementation process of the executive, meaning the members of Congress just assist in filling up the details of the law? Is the authority recommendatory or mandatory?
Your Honor, well, my answer would be guided by Abacada versus Purissima. Whether it's recommendatory or mandatory, right now the jurisprudence requires that no effective act be done after the law has taken effect. Any role, any manner, as long as the law has come into effect.
Okay, now, would you agree that the Philconsa ruling will only apply if the exercise of the authority is part of the executive's implementation of the project?
Yes,
Because
Your Honor.
Philconsa says the authority to identify is recommendatory.
It viewed in that way, Your Honor, Philconsa, yes, says that it is only recommendatory.
Now, let us go to the LAM case. What is the subject matter in the LAM case? What
Your
is
Honor,
the
it was
GAA
again
involved?
the GAA for 2001, Your Honor.
How about in the instant case
It's 2013, Your Honor, and the 2014 NEP.
and the other appropriation laws containing
Yes, Your
Pdaf?
Honor.
So having different subject matters, will the principle of res judicata apply?
No, Your Honor.
Okay. Now let's go to stare decisis. In light of the COA report, do you think the principle of stare decisis in connection with the LAMP ruling would apply?
Your Honor, we are already operating under a different set of circumstances from LAMP.
What is the basis of the denial of the petition in LAMP?
The basis, Your Honor, if I may recall, is that there was a lack of convincing proof presented by the petitioners during that time.
Okay, and with the COA report now?
Today, Your Honor, this is a markedly different proposition.
So the COA report now is your evidence?
Well, Your Honor, it is our third-prong argument, yes, especially since, Your Honor, the COA report is not just a mere newspaper clipping referred to in LAMP. It is actually the official act of a constitutionally mandated organ of government whose very duty is to account for these funds, audit these funds.
Okay, thank you, counsel. Can I call on Attorney D?
Good afternoon, Your Honor.
Good afternoon, Attorney D. The appropriation for the Malampaya funds is found under Section 8 of PD 910.
Your Honor,
Is that-
PD 910 provides that a special fund is created, and that is what they call the Malampaya Fund.
And this was issued by then President Marcos way back in 1976.
Yes, Your Honor.
Now, how do you construe the phrase, "and for such other purposes as may be hereafter directed by the President"?
That phrase should be construed as authorizing the President to determine any other purpose that he deems would be appropriate, wherein the fund should be used or applied. It authorizes the President to use for purposes even outside of energy, resource exploitation, and development.
So you do not believe that the phrase pertains to the purpose of financing energy resource development and exploitation programs and projects of the government?
No, it's more than that, Your Honor. The phrase such other purpose means using the funds even other than financing energy, resource exploitation, and development, Your Honor.
So you think it's for purposes not related to energy resource development
Yes,
and exploitation?
Yes, it authorizes the President.
Now, the President's Social Fund is sourced from the gross earnings of PAGCOR under Section 12 of PD 1869.
Yes, Your
Likewise
Honor.
issued by President Marcos in 1983. Now, what is the purpose of these funds?
Your Honor, it states there that it will be used for purposes of for doing infrastructure and social civic projects, Your Honor.
Now, can you read the infrastructure and social civic projects enumerated under the law? You have A to G.
Yes, Your Honor. Section 12 provides, Your Honor, after deducting 5% as franchise tax, the 50% share of the government and the aggregate gross earnings of the corporation from this franchise shall be immediately set aside and allocated to fund the following infrastructure and social civic projects within the metropolitan Manila area. Letter A, flood control. Letter B, sewerage and sewage. Letter C, nutritional control. Letter D, population control. Letter E, tulungan ng bayan centers. Letter F, beautification. Letter G, ilusang kabuhayan at kaunlaran projects.
Now, do you think the phrase may also be appropriated and allocated to fund and finance infrastructure and socio-civic projects throughout the Philippines as may be directed and authorized by the Office of the President of the Philippines, merely expands the scope of these projects to places outside the metropolitan Manila area?
It does more than that, Your Honor. It gives the President the authority to appropriate the funds himself. When, under the Constitution, the authority to appropriate is lodged with Congress by passing a law.
Okay. Now, on the prayer to partially lift the TRO, do you think that the TRO on its use should be partially lifted for the limited purposes of education, educational and medical assistance?
Your Honor, we understand the plight of these students, scholars, and indigent patients, that they are clamoring that the funds under the Pdaf should be released. We understand their situation, Your Honor, but unfortunately, Your Honor, the Honorable Court is mandated to uphold the Constitution. So unless they can show compelling reasons why it should be lifted, Your Honor, and on our part, we have shown that the Pdaf is unconstitutional, there's no reason why it should be lifted, even if they're clamoring for purposes of humanitarian reasons, Your Honor.
Okay. Thank you, Counsel. I have no further questions, Chief.
Justice Garfield.
Please sit down. I would like to direct my questions to Attorney Molo.
Good afternoon, Your Honor.
Good afternoon, Counsel. Let's go to Malampaya first. Now, the power to appropriate is a legislative power lodged in Congress, correct?
Correct, Your Honor.
Okay. The power to appropriate means Congress will authorize the executive and order the executive to pay government funds for a specified purpose or under specified conditions. That's the definition in the Revised Administrative Code, correct?
By law, Your Honor, yes.
Yes. So,
by law.
So, in other words, when Congress appropriates, it must specify the purpose of the fund.
Yes, Your Honor.
Okay. So, if Congress says 1 billion for contingency fund, that is valid, correct? That is,
Yes,
there is
Your
a
Honor.
purpose for contingencies, and that's recognized in budgeting and accounting as a valid purpose, correct?
Yes, Your Honor.
If Congress says 1 billion for calamity fund, that's also valid. There's a purpose, correct?
Yes, Your Honor.
1 billion for intelligence fund, that's also valid, correct?
Yes, Your Honor.
Okay. when Congress says 1 billion for a special purpose fund without saying what is the purpose, valid or unconstitutional?
Well, what is the, on those terms, Your Honor, I would have to say unconstitutional, Your Honor.
Yes, because if you say special purpose fund, you must specify the purpose. When you say special purpose fund without specifying the purpose, so it can be any purpose actually, and that is abdication of the power to appropriate to the President. The President will decide the purpose. The purpose must be determined by Congress, correct?
Yes, Your Honor.
So we go to the Malampaya Fund, PD 910. It says the President may use the fund for such other purposes as he may determine. So the President can use the fund for any purpose actually, correct?
Correct, Your Honor. And they have.
So that is an abdication by Congress of the power to appropriate, because Congress must specify the purpose, correct?
Correct, Your Honor.
Now, PD 910 was promulgated during martial law. The President then was the executive and the legislative as well, correct?
Correct, Your Honor.
So there was no problem because he was the legislature also. Now, when Batasan Pambansa came into being, there was also no problem because the President retained his lawmaking powers, correct?
Yes, Your Honor.
But when Congress was restored under the 1987 Constitution, there was now a problem.
Yes,
because the President could not exercise the power to appropriate anymore. Under that provision, the President may use the Malampaya Fund for any purpose he determines, correct?
Yes, Your Honor. As
So
we
it
argued in
became
our reply.
unconstitutional when Congress convened, correct?
Yes,
because
Your
when Congress convened, President Cory Aquino lost her legislative powers, correct?
Yes, Your Honor.
Okay, so it's simple. On its face, the Malampaya Fund, that PD 910, giving the President the power to use the fund for any purpose he wants, on its face, that is unconstitutional, correct?
Yes, Your Honor.
So you don't need any COA report to declare it unconstitutional because it is facially unconstitutional, correct?
On its face, Your Honor, yes, Your Honor. That's why we
Okay.
didn't even.
Let's now go to the Pdaf. Well, the executive power is vested in the President, correct?
Yes, Your Honor.
And it cannot be shared by the President with the legislature, correct?
No, Your Honor.
Okay. Any sharing is unconstitutional, correct?
Yes, Your Honor.
Okay, let's go to the Pdaf provisions. Now, the Pdaf provisions says the Secretary of Agriculture, Trade, etc. can realign funds. Is the power to realign, can it be delegated to the cabinet secretaries or is it lodged solely in the President? The Constitution says the President can realign savings within the Executive Department. The Chief Justice can realign savings within the Judiciary. The Speaker within the House, the Senate within the Senate, and the constitutional heads of offices within their respective appropriations.
Yes, Your Honor.
So that power cannot be delegated to the cabinet secretaries, correct? That has
Yes,
to
Your
be
Honor.
exercised by the President.
The enumeration, Your Honor, in the Constitution would be exclusive, Your Honor.
Okay, so this provision in the Pdaf, Roman numeral 45 of the 2013 General Appropriations Act, this provision giving the cabinet members the power to align is unconstitutional right there and there, correct?
Yes, Your Honor.
Now, it also says that the power to realign can be exercised by the cabinet secretaries upon concurrence of the Senate Committee on Finance and the House Committee on Appropriations, correct?
Yes,
It says
Your
here.
Honor.
So, you have here a power exclusively belonging to the President being shared by a committee of the House and a committee of the Senate. Is that constitutional?
No, Your Honor.
So right there and there is facially a provision that's unconstitutional. Two already.
Yes, Your
The
Honor.
power given to cabinet secretaries to align, that's unconstitutional on its face, correct? You don't need a COA report for that, correct?
Yes, Your Honor.
The power given to the Senate committee and the House committee to concur before there can be a realignment, that's unconstitutional on its face, correct?
Yes, Your Honor.
We don't need a COA report for that, correct?
Yes, Your Honor.
Okay. Let's go to another provision. It says, any modification and revision of the project identification shall be submitted to the House Committee on Appropriations and the Senate Committee on Finance for favorable endorsement. In other words, there can be no modification or change in the project identified by the legislator unless concurred, approved by the Senate Committee and the House Committee, correct?
Yes, Your Honor.
So, in other words, when the legislator identifies this project, that's my project, that is binding already on the executive. The executive cannot change that without the concurrence of the Senate or House Committee, correct?
Yes, Your Honor.
Okay, so this identification by the legislator under the 2013 General Appropriations Act is mandatory. It's binding on the executive, correct?
Yes, Your Honor.
Okay. In Philconsa and in LAMP, we said the identification is only recommendatory, correct?
Yes, Your Honor.
Okay. Let's go to Philconsa. What, in the Philconsa case, the Pdaf provision contains only how many paragraphs? In the, you go to your
I will get my copy.
Philconsa case. Yeah, that's the 1994 case penned by Justice Quezon.
Yes, Your Honor.
Okay, there is,
There
the
are two
case
paragraphs.
quotes the special provision of the General Appropriations Act for 1994.
Yes, Your Honor.
Okay, there are only 3 paragraphs there, and there is nothing there which says that the House Committee or the Senate Committee must concur to any change in the identification. There's nothing there which says that the House Committee or the Senate Committee must concur with any realignment.
Nothing, Your Honor.
There's nothing there that says that the House Committee or the Senate Committee must approve any release of funds, which is in the 2013 Pdaf, correct? Any release of funds, any SARO released by DBM must be approved by the House committees or Senate committees.
There's none
correct?
here, Your Honor.
So, clearly, in Philconsa, the provision that was before the court was a purely recommendatory Pdaf that the legislator just recommends on its face, correct?
Yes, Your Honor.
Okay. So, in Philconsa, the court decided the case different from the provisions before us now. There's no comparison at all, correct?
Yes, Your Honor.
In Philconsa, the provision of Pdaf was recommendatory, clearly on its face.
Yes, Your Honor.
Here, it is mandatory,
Yes,
the
Your Honor.
identification. So Philconsa is not a precedent. This is a different animal from what we're facing today, correct?
Yes, Your Honor. That's our
Okay, let's go
second
to
prong
LAMP,
argument.
2004. What is the special provision on Pdaf in LAMP?
Your Honor, the case...
There is only one paragraph.
Yes, Your Honor.
It does not even mention legislator. It does not mention allocation to legislators. In fact, it has no reference at all to the Senate or the House. Correct? Anybody can recommend under this provision. So this provision on its face doesn't say anything. It doesn't even say that the funds project shall be identified by the legislator. Correct?
Yes, Your Honor.
So, the decision in LAMP was correct because the provision facing the court at the time, in 2004, was a harmless provision. There was not a single word saying that the legislator shall identify the project. Correct?
Yes, Your Honor.
We now come to 2013, the Pdaf provision before us. And there is another provision, release of funds. All requests for release of funds, this is the SARO, correct?
Yes, Your Honor.
Shall be favorably endorsed by the House Committee on Appropriation and the Senate Committee on Finance. So that means the executive cannot spend the money without the concurrence of the House Committee on Appropriation and the Senate Committee on Finance, correct?
Yes, Your Honor.
So that's unconstitutional because that is an executive function to release the funds. The budget has already been approved, correct?
Yes, Your Honor.
Okay, so it's on its face, this provision is also unconstitutional. So we are deciding here before us a completely different Pdaf provision from the one that was facing the court in 2004 and 1994, correct?
Yes, Your Honor.
Okay, so those two decisions are not precedents whatsoever. Correct?
Yes, Your Honor. Phrased that way.
So, now you mentioned that when the Constitution says Congress shall appropriate, all appropriations shall emanate from the House, but Senate can concur with amendments. Okay, that's the provision in the Constitution. When the Constitution says Congress, can it mean a committee of the House or a committee of the Senate? Cannot.
No, Your Honor.
It has to be both of them acting as a body, correct?
Yes, Your Honor.
It cannot also be one legislator, correct?
Definitely
So
not,
when
Your
the
Honor.
legislator is allowed to identify post-enactment of the GA, that is even unconstitutional because it's not even Congress. The legislator is not Congress.
Yes, Your Honor.
Even the House committee is not Congress, correct?
Yes, Your
We
Honor.
have ruled on that in several cases already. A House committee cannot bind Congress, correct?
Yes, Your Honor.
So, in the end, this is very simple. On its face, you don't need a COA report. You can declare Pdaf unconstitutional because, one, on the expenditure of funds, it says the President cannot spend the money in the GA without the concurrence of the Senate Committee on Finance and the House Committee on Appropriation. That is unconstitutional, correct?
Yes, Your Honor.
Because the GA has been approved already. That the Cabinet Secretary can realign, that's unconstitutional. That the House Committee or the Senate Committee shall concur with their alignment, that's unconstitutional. That the legislator will identify the project and that's binding on the executive, that's unconstitutional, correct?
Yes, Your Honor.
So it's very simple. But the 2013 provision on PDAF is not found in prior years, correct?
Yes, Your Honor.
It's only in 2013 that you can find this, correct?
Yes, Your Honor, based on our study, Your Honor.
Okay. It looks like that the Department of Budget just put into the law their practice, correct? Their practice before 2013, they just put it in the law.
Based on the circulars we looked
Yes,
at, Your Honor, yes.
it accumulated because at first they were, I think, cognizant that the legislators cannot execute the GAA, correct?
Yes,
so
Your
they said, oh, that's only recommendatory. But they forgot that. So they put everything now in the 2013 budget, GAA. And that's the problem now because it is riddled with unconstitutionalities, correct?
Yes,
On
Your
its
Honor.
face. We don't need a COA report, correct?
No, Your Honor, for 2013.
Okay, thank you, Counsel.
Okay, Justice Perez.
Just to complete the facial unconstitutionality, is there any difference between project identification post-GAA and project identification pre-GAA?
Yes, Your Honor.
And what is it?
Your Honor, pre-GAA, it follows the finely wrought procedure in the Constitution of budget approval. It has to pass through the committees of House, and it has to be voted upon the plenary, and then after that, you have the second safety valve of the Senate. Post-GAA, Your Honor, there's a big difference. If I can use the fact stated in the COA report, you can do it by phone call, a mere letter.
In other words, what is unconstitutional is a post-GAA identification of project, not a pre-GAA identification of project, because that identification is part of the legislative process of appropriation.
Yes, Your Honor.
So this is the coup de grace. What is stated in condition or special provision number 2 is that I'm reading verbatim, the implementing agency shall submit to Congress priority list, standard or design within 90 days from effectivity of this act. And that renders it absolutely unconstitutional because this is post-GAA project identification, correct?
Yes, Your Honor.
And that concludes all the facial unconstitutional features of this law. Thank you, Mr. Counsel.
Thank you, Your Honor.
Justice De Castro, would you want to answer your questions?
Let's see. So with the discussions we just had, how do you classify the funds of the Pdaf? Is it legislative or executive funds?
Your Honor, I will quote the DBM based on what they say. They consider it a special purpose fund because it is outside the allotment for Congress.
Oh, is it an executive fund or a legislative fund?
In effect, Your Honor, it's an executive fund.
It is a
Executive fund, Your Honor.
executive? You mean to say it's the executive branch of the government which has control over that?
Well, no, Your Honor. Based on how it is placed in the GAA, I'm just following how the DBM classifies it. They say that if it's not within the budget stated for Congress, probably for MOEE, it becomes a special purpose fund, but not for Congress.
But who has control over the money?
Effectively, it's Congress, Your Honor.
Oh, okay. Now, before 2010, from 2010 and the years before that, there's no mention about a specific allocation for members of Congress. Do you agree?
Yes, Your Honor.
Now, what was the practice before? Before 2011, was there also a fixed allocation which is not found in the law?
No, Your Honor. Based on our review of the previous ones, there's no fixed allocation, Your Honor.
There was no
fixed allocation of Pdaf, Your Honor.
no fixed allocation. You don't agree that in 2010 each member of the House of Representatives was allocated 40 million and the senators 120 million per year? You don't have that in your study?
I must have missed that, Your Honor. Forgive me. But
the allocation in the amount of 70 million and 200 million is started in 2011. Is that right?
yes, Your Honor.
Now, do you know how the executive and Congress determined this amount that they included as Pdaf?
I don't know, Your Honor, how they come up with these amounts.
You do not know the basis for this?
For 70 and 200, Your Honor, no.
So, in 2011 and 2012, as well as in 2013, the Pdaf is pegged at 70 million for congressmen and 200 million for senators?
Yes, Your Honor.
Okay. So, do I get it correctly that if the legislators have identified the where the money will be spent, the president cannot disregard that anymore?
No, Your Honor. In fact, even to realign it, they can't even get it without the concurrence of the legislator.
Now, all of these expenditures should be subject to the procurement law and also to the liquidation and accounting mechanism prescribed by the COA.
Yes, Your Honor.
I'd like to ask Chairman Pulido, will you step aside for a while and I'll ask Chairman Pulido.
Your Honor.
It would seem that the alleged misuse of Pdaf has been going on for many years. Where has COA been all along?
Your Honor, I wish I could answer that question, but I was not even in COA even before that time. But what we have seen in our audit of 2007 and 2009, show that the practice, in fact, has really been that a legislator would identify a project that he wants for his district, make the request to the Appropriations Committee in the case of the lower house, or the Finance Committee in the case of the Senate, and then the Senate President and or the Speaker of the House, as the case may be, would transmit the request to the Department of Budget and Management, on the basis of which the DBM would issue the SARO and consequently the NCA. The process was really as simple as that. For its part, the DBM has a circular. It's called the National Budget Circular of number 467, if I'm not mistaken. And this is entitled Guidelines in the Release of the Pdaf for the second semester of fiscal year 2001 and thereafter. So that was still the same budget circular that was being used for the period under audit, which were 2007 to 2009. We found, however, Your Honors, that even the NBC, this National Budget Circular, which requires, among others, the submission of a project profile that is concurred in by a project profile that is supposed to be endorsed by the implementing agency and concurred in by the proponent legislator, should be attached to the request for release of funds from the Pdaf allocation, but this was not even being followed. So the practice has, according to the DBM, which we also found during our audit, that has been the practice really ever since. And insofar as the allocations are concerned, there was nothing by way of specific amounts in the 2007 to 2009 GAAs, no 70, no 40, but again, as a matter of practice, the funds were actually coming from two lump sum appropriations. One, the Pdaf itself, which is under the title on Pdaf in the GAAs. This was supposedly the 30 million component for representatives, meaning congressmen and party list representatives, and 100 million for senators. Ito po yung sinasabi nilang soft. The other portion was coming from another lump sum appropriation, which was under the budget of the Department of Public Works and Highways. Ito po yung tinatawag naman nila na various infrastructure, including local project. This is the source of the so-called hard project, hard portion. Ito po yung 40 million kung representative or 100 million kung senator. So our report actually covers both the Pdaf under Title 15 or 19 of the GAAs for those years, and the VILP under the title, the budget of the DPWH. These are all lump sum items of appropriation, Your Honors, meaning that there is really no breakdown. There is no mention that it was going to be the allocation for senators and representatives, or that there was even no mention on how it should be released by the DBM. Pretty much the situation of the GAA in 2004, which was the subject matter of the LAMP case, Your Honors.
Regardless of the lump sum appropriation for the items mentioned in the Pdaf, the issue here is that we have a general audit accounting and auditing code.
Yes,
Don't you
Your
think it was up to COA to see to it that the DBM regulations are consistent with the general accounting and auditing code, and that you are not bound by the regulations of the DBM? You have your own constitutional duty to do your work.
Yes, Your Honor, and precisely that's what we meant to discharge, and we hope we discharge it well during this period from 2011 to the present, where we undertook and completed the 2007 to 2009 audit. As I mentioned earlier, I wish I could answer for the previous years, Your Honor, but I was not with COA at that time, and I really am blind to what may have happened before 2011. I wish to make it of record, Your Honor, that the 2007-2009 report was started by my predecessor in office in 2010, and I came into the commission in 2011, so I continued with it, and completed it and released it in 2013, Your Honor.
You cannot just put the blame on the officials of COA before you, because we rely on institutional continuity. COA should have done its part. If it has done so, we will not be encountering problems like this.
With due respect, Your Honor, I did not mean to put any blame on my predecessor. I think all I'm saying is that I'm sorry, I cannot explain.
Just one short question from Justice Carpio to the COA chairperson.
Yeah, Chairperson Tan. Are you coming out with a COA audit report on the 2011 and 12, 2010, 11, and 12 Pdaf?
Your Honor, we are not undertaking any more special audit of the Pdaf for these years, 2010 forward. Because what we did while we were undertaking the 2007 to 2009 report, and we were already seeing some kind of a pattern, what I did as head of agency, Your Honor, was to instruct all our auditors in the different agencies of government that in the regular audit per year, that they should also look into the Pdaf funds the way it was also utilized. And that is what our auditors have done, Your Honor. So apart from the 2007-2009 special report, we have in fact released reports on an agency basis from 2010 to 2012, where we also raised certain findings regarding the use of Pdaf, and these are pretty much the same as what we found in the special report, Your Honor.
Yeah,
we have 2010, 2011, 2012 reports, and I may perhaps give some examples if you will allow me, Your Honor. For 2010, our audit report on the city of Antipolo, for example, would include findings on Pdaf. For 2011, 2012, we have the municipalities of Dinalupihan, Bataan, Pilar, Bataan, also NABCOR and ZREC, which we also found in 2007 and 2009. So they're really scattered on a per agency basis, Your Honors.
But in these regular agency audits from 2010, 11, and 12, did you also verify, did you go to the legislators and their staff to verify the signatures as you did in the special audit for 2007 to 2009?
Your Honor, it is a standard audit procedure that we conduct the necessary verification, and I would say that we have been very careful in this regard.
So you're saying that what was done in the special audit is actually being done in the regular agency audit?
Your Honor, yes, including the validation of reported projects and the reported beneficiaries.
And you have finished already the regular agency audits for 2010, 11, and 12? Is that what you're saying?
For specific agencies where we found them, Your Honor, because not all agencies received funds allocated from the Pdaf, or if they did, the uses were not the way it was used as represented by the 2007-2009
Are these reports in your
audit.
website already?
Yes, Your Honor.
Okay, thank you. Thank you, Chair.
Justice Del Castillo, Justice Abad, then Justice Leonen.
I'd like to address this to Attorney Molo. It would seem
Your
that
Honor.
all the relevant questions have already been asked. But there's just one aspect of the realignment of the Pdaf funds that I'm curious about. Would you know why the legislators are just allowed once to realign their Pdaf funds? Why are they allowed only once?
I'm sorry, Your Honor. I have no idea why they are only allowed once, Your Honor.
Well, if you find the answer, just include it in
I
the
will
memorandum.
include it in the memorandum, Your Honor.
Okay, thank you.
Trustee Sabad.
To the chairman of the Commission on Audit.
Chairperson Tan, please.
Your Honor.
I've been reading some of the General Appropriations Act, and I noted that each item of expenditure essentially consists of three things. Correct me if I'm wrong, because I'm just a layman in the matter of budget. I found three things there in every item. First is a sufficiently specific description of the particular work, activity, or purpose for which the government money is to be spent. You agree with that? That's one of the, well, the ordinary things, you know, the ordinary items. So a specific description of the particular work that is to be done. And second, I found the specific amount of money that can be paid out of the National Treasury for that work, activity, or purpose. And third, the particular government agency or unit that will implement the work, activity, or purpose. These are the three things that I think I found in each items. You know? These are the things that really zeroes in on what expense and how it will be spent and who is going to spend it. Do you agree with me?
As a general proposition for items of appropriation,
Yes.
specific appropriations, Your Honor, yes.
Yes, I'm referring to that. Now, when Article 6, Section 29, Paragraph 1 of the Constitution provides that no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. This means that only Congress can decide for what work, activity, or purpose public money can be spent for and for how much. Do you agree?
Yes, Your Honor.
Now, the President has no power to decide for what purpose and for how much public money will be spent under the Constitution. Is that correct? That's why the power of the purse belongs to Congress.
Yes, Your Honor.
Yes, because you cannot implement, you cannot audit all these expenses unless you know these fundamentals.
Yes.
That public money cannot be spent out of the Treasury without a valid appropriations. Do you agree with me?
Yes, Your Honor.
And this is what has guided you in your work, correct?
Yes, Your Honor.
Now, to comply with the Constitution, Congress should be able to control the purpose for which money will be spent and how much. Is that right?
To control meaning
To
post-legislation,
be
Your
the one
Honor.
to decide for what purpose and for how much appropriations will be made. It is Congress. You
It is-
agree with that or not?
Yes, Your Honor.
Okay.
Yes, Your Honor. But I think the question
Now,
was
can
posed
Congress
after.
delegate that power to appropriate to the President?
No, Your Honor.
No, okay, that's clear now. Because Congress would have ceded its power to appropriate to the President, which is not allowed. Do you agree with me?
Yes, Your Honor.
Now, so the appropriation of an amount of public money can be spent only if the purpose is so sufficiently described that it is the will of Congress that is carried out, not left to that of the President. Do you agree?
Yes, Your Honor.
Right. Since the President has no power to appropriate public funds, correct?
Yes, Your Honor.
Now, I remember that prior to martial law, when I was still quite young, each item in the General Appropriations Act was described in small details, like salaries for one bureau chief, 800,000 pesos, one assistant bureau chief, 700,000 pesos, 10 sections head, 5 million, etc. Have you heard of that old practice where the budget details all these items?
No, Your Honor.
No, well, you're too young for that, but that's what before martial law. Now, it is so detailed that we could perhaps call it detailed description of the budget. Later, small items like salaries, small items of the same kind within one agency are bundled into only one item like general administration and support services. Yan lang description. All right? Already covering all salaried positions for the Bureau. Say a lump sum of, say, 120 million. This is how it is done now. Is that correct?
Yes, Your Honor.
Okay. It is less detailed but specific enough for you to be able to audit expenses of the government. Is that correct?
Yes, Your Honor.
Now, even if the small items, the details are omitted, actually, is it not a practice that when the executive department presents its budget of expenditures, although these are stated in those specific bundled items, by bundled details, actually, they supply Congress also with the breakdowns of these items. Do you agree?
Yes, Your Honor.
Okay, so there's also a breakdown, which is also part of the documentation of the budget. So it says, for administrative expenses, but attached to that, the positions and the salaries, etc. Do you agree?
Yes, Your Honor.
Now, let us, does this way of describing each item of appropriation in the General Appropriations Act keep the power to appropriate public funds under the control of Congress and enables you to say that money is being spent as Congress has willed it under this present practice?
When we do audit, Your Honor,
Yes.
we actually go by what is described and put forth
Sufficiently
in
described in the
GAA. Yes, Your
in
Honor.
the GAA, yeah. Now, let us go to an extreme, an opposite extreme. Suppose the GAA contains just one sentence. The amount of 2 trillion pesos is hereby appropriated to the executive department to be spent for public purposes. Does that way of doing it keep the power to appropriate public funds under the control of Congress?
Your Honor, I will speak here of our role as auditors. In that case,
Even as an accountant, as
Yes.
a co-auditor, can you say what Congress, how Congress wants money spent?
In that theoretical case, Your Honor, I can imagine. I would suppose that what we will
because
do.
under such case, Congress surrenders to the President its power to determine what specific work, activity, or purpose will be funded and with how much. You agree? In that way, that's the wrong way. Okay. Suppose the GAA contains an appropriation for the DSWD of 80 billion pesos for social welfare development. Nothing more. So it's a lump sum appropriation of 80 billion to the DSWD for social welfare development. Does that way keep the power to appropriate funds still within the control of Congress?
If the appropriation is only as to the amount and nothing more is said, Your
Yes,
Honor?
the amount. And then for social welfare development, does that enable you to audit it properly?
It will be very difficult, Your Honor,
It
if at all
won't, okay.
possible.
Because under such case, if you do it that way, Congress surrenders to the DSWD its power to determine what specific work, activity, or purpose will be funded and with how much. Is that correct?
Yes, Your Honor.
Now, so 3 things are needed to keep the appropriations of each item within the control of Congress. First, a sufficiently specific description of the particular work, activity, or purpose for which government money is to be spent. Second, the specific amount of money that can be paid out of the national treasury for that work, activity, or purpose, the specific amount. Okay? And third, the particular government agency or unit that will implement the work, activity, or purpose. Otherwise, you cannot audit it. Okay, do you agree?
Yes, Your Honor.
Now, the Malampaya law appropriates money the government derives from mining gas in the Philippine Sea. Do you agree?
Yes, Your Honor.
It provides that all fees, revenues, and receipts from this exploitation of our natural resources shall form part of a special fund to be used to finance energy resource development and exploitation program of the government, and for such other purposes as may hereafter be directed by the President. Right. You remember that?
Yes, Your Honor.
So, you're the one to audit it, correct?
Yes, Your Honor.
Yeah. Does the Malampaya law describe, does Congress in the Malampaya law, or the President, when the original Malampaya law was a petition decree, does Malampaya law describe the specific work, activity, or purpose for which the earnings of Malampaya oil mines is to be spent in the way specific appropriations are made in the Appropriations Act? Does it?
It is a very, we find it to be a very
It does not.
generic.
It's like the DSWD appropriations for social welfare development. This one is for energy resource development.
And exploitation.
Somewhat,
Your Honor.
no, okay. So, it appropriates billions of public money to finance energy resource development and exploitation programs. Does the Malampaya law specify the amount of money that can be paid out of the national treasury for some specific work, activity, or purpose stated in the law? Like, for example, I found in one of the budget, construct one hydroelectric plant in Albay. That's what the appropriations law says. It's so specific. Does the Malampaya law identify the energy project?
No, Your Honor.
No, it does not. No. In effect, well, does the Malampaya law name the particular government agency or unit that will implement the work, activity, or purpose?
No, Your Honor.
It does not, because
the funds are
the
managed.
President who says, oh, this one will go to this department or to that department. So, Congress has surrendered to the President the authority to appropriate such billions of money, public funds, for the broad purpose of development of energy. All right. In effect, the Malampaya law removes, as I said, from Congress the power to appropriate billions of government incomes from its gas well. Is that right? But you don't have to answer it. Okay. Thank you.
Thank you.
Justice Leonin.
May I ask Professor Molo to go to the podium? The position of the petitioners in response to the questions of some of the justices is that it is perfectly all right for members of the House and the Senate to identify the projects before the General Appropriations Act is signed by the President, but it is not all right for them to identify the project after. Is that your position?
Yes, Your Honor.
So, theoretically speaking, the current Pdaf now, which is 40 million for infrastructure projects, each of the members of the House may identify infrastructure projects equivalent to 40 million, detail it, and put it in the General Appropriations Act, and that would be perfectly all right. Is that correct?
If they do it before
the President signs the GAA.
Yes, Your Honor.
Yes. What's the difference between that and allowing them the 40 million and giving them a choice after the President signs it? We just need to understand why there is a constitutional difference from your point of view.
From our point of view as the petitioners, Your Honor, is that appropriation is both a legislative purpose and a specific purpose of appropriation. So it's not just governed by Section 25, it's also governed by Section 26. And if it is a legislative purpose, Your Honor, it is doctrine that the legislative
But it will
power...
be the same 40 million given to each member of the House if it is done before the General Appropriations Act is approved by the President, with or without item veto, of course, then it's to you perfectly constitutionally valid. But after, if there is 40 million each, and it is the only time that they identify after the GAA, then it is unconstitutional. Is that not correct?
Yes, Your Honor.
Same value, 40 million.
It's not about the value, Your Honor. It's about following the specific manner by which Congress can appropriate as found in the Constitution, Your Honor.
Should flexibility also be given to those who represent very local communities, in the sense that maybe while the General Appropriations Act is pending in the House and in the Senate, they cannot yet identify, but only after the GAA. You see, we are told that some of the Pdaf is used for, let us say, reconstructing after a typhoon, apart from, of course, the calamity funds, special purpose funds that are included in the budget. I'm just asking this because I want this covered also in the memoranda.
Yes, Your Honor. We agree, Your Honor, for good purposes and for the sake of efficiency and flexibility, that can be done, provided it is done within the budget deliberations, Your Honor. I mean,
budget deliberations take place
before the
almost at the third or fourth quarter of every year, correct?
Yes, Your Honor.
And we want the members of the House and the Senate to predict everything that will happen for the next year. Is that not correct?
Yes, Your Honor.
Because if there is no such discretion on the member of the House and in the Senate for local contingencies, who will attend to that?
It's the executive, Your Honor.
The executive taking it from
the appropriations granted.
Special purpose funds, which can be the Calamity Fund, which can be the Presidential Social Fund, correct?
The Calamity Fund, Your Honor.
Yes. So we are, of course, going to change the political landscape here. Is that not correct? Which will mean that the President is going to be more powerful, even more powerful in terms of choosing which local community is going to get what. Is that not correct?
Well, Your Honor, allow me
But that is not the concern of this court.
Sir.
Is that not correct?
It is not about whether the President...
Our concern is simply whether we follow the Constitution or not, regardless of the political consequences.
Yes, Your Honor.
In Philconsa, there is this phrase. In fact, Philconsa referred to the Pdaf as, or then the pork barrel at that time as imaginative as it is innovative. And it said that the Pdaf, or the Countrywide Development Fund then, is used to equalize the unequal. Can you explain to us what was meant in that decision? Why was the Countrywide Development Fund imaginative as it is innovative, and at the same time to equalize the unequal?
Your Honor, it was alleged in the decision that prior to the GAA in 1991, there was uneven allocations.
Because if it is congressional insertion prior to the enactment of the GAA, it would mean that there will be the political dynamics within the House and the Senate. Is that not correct?
Yes, Your Honor.
And certainly those in the majority, those that can control maybe the Committee on Appropriation or the Committee on Finance in the Senate, and the majority party will be able to distribute the largest among the members, correct?
Yes, Your Honor.
Is this unconstitutional?
Unfortunately, even if it is unfair, it is not unconstitutional, Your Honor.
So so what we're saying is that removal of the Pdaf per se does not solve some of the political problems that we have at present.
No, Your Honor. We never
But that is not our
represented it.
concern, correct?
Yes, Your Honor.
And the political problems are supposed to be attended to by the House, the Senate, and the President responding to the people. Is that not correct?
Yes, Your Honor, in their day-to-day interactions.
And your point here now is only with respect to Title 44, the Pdaf, at least insofar as your presentation is concerned.
Yes, Your Honor.
Okay. The VILP, again, Counsel, can you enlighten us as to what VILP means?
VILP is various infrastructures and local projects, Your Honor.
At the outset of this new administration, during their first budgetary year, they changed the allocation for the VILP and that of the Pdaf. Can you enlighten us on what the change was in relation to VILP?
Your Honor, I believe that they folded in the VILP along with the Pdaf, Your Honor.
Why is that?
Your Honor, because based on what they said, Your Honor, as I recall, it was already unfair and a source of corruption. That's why they had to fold it in.
Would you know if the present budget still has a VILP item in it?
It no longer has, Your Honor.
I think it's in page 998 of the General Appropriations Act. Okay. The DPWH budget still has a VILP of how much?
I don't have the figure.
It still has a VILP of 5 million. Is that not correct?
I believe so, Your Honor.
So why is there still a VILP in the DPWH budget when what appears is that they folded in the VILP with the Pdaf already?
I would not hasten a guess on why they actually duplicated.
What are the rules in terms of realignment of savings? Would you know, Counsel?
First, Your Honor, there must be a savings. And then second, Your Honor, the savings must be taken from an item, previously existing item. And then
if there is no item called VILP, can savings be realigned to various infrastructure local projects other than Pdaf?
No, Your Honor.
So there is still a VILP 5 million, and could it be that would be the purpose?
Perhaps, Your Honor.
Is that constitutional? To maintain a line item for the purpose of transferring to that item should there be savings. This is theoretical, of course, but since we're looking at a facial challenge, as you said a while ago, then we better look at all the possibilities.
I would say it's not, Your Honor.
In fact, various infrastructure and local projects, is that a legitimate purpose?
It's too broad, Your Honor, if it's my personal.
While we're into that, what are the rules with respect to a valid item in terms of an appropriation?
It must specify, Your Honor, the specific purpose, the specific amount, and the implementing agency or organ of government that will carry out the work.
And that it must have a source of funding. Is that not correct?
Yes, Your Honor.
At least insofar as the General Appropriations Act is concerned.
Yes, Your Honor.
How specific must the purpose be? Do we apply the rules on unlawful delegation of legislative power when we tackle appropriations items?
Yes, Your Honor.
Really? Do you have jurisprudence already stating that when we look at the purpose of an appropriation, it should be that it passes the unlawful delegation test, similar to all ordinary provisions in an ordinary law?
No, Your Honor.
So in that case, you are proposing new jurisprudence to look at the purpose. Or should the purpose be depending on the President and the Congress? If they understand each other, giving them their political wisdom, then if it says school building, then it's up to them if they can construct a big or small school building, an elegant or a simple school building for that matter.
Yes, Your Honor, it's up to them.
And probably this can be further discussed because in terms of your pleadings, a lot of it is about unlawful delegation of legislative powers. But I am not aware of any jurisprudence which tests the validity, constitutional validity of an item in an Appropriations Act in relation to that.
We will discuss that in the memorandum, Your Honor.
Section 2. Can you read Section 2 of the special provisions in the Pdaf, Title 44?
Your Honor, Section 2 is project identification.
Yes, can you read it in
Identification of projects and or designation of beneficiaries shall conform to the priority list.
A priority list to be submitted by the...
Implementing agency, Your
So
Honor.
it's the implementing agency that comes out with a priority list.
Yes, Your Honor.
This is a sub-sub menu, correct?
Yes, Your Honor.
So within each item of the menu, there is still a priority list, but this is not presented by the member of Congress, but presented by the implementing agency.
Yes, Your Honor.
So in terms of project identification, what is your position? Who identifies the project?
Your Honor, it's the legislator.
In spite of the fact that the implementing agency curtails the discretion into a priority list.
Your Honor, it's not about canalizing or curtailing discretion. It's all about who makes the choice of the project.
Where in the special provisions is it very clear that the congressman or the senator will demand or has final say in terms of the project? Maybe I will put it this way. Has there been any disbursement of funds in this administration by the DBM to any local government or local constituency without the concurrence of a member of the House of Representatives?
I am not aware of what the DBM has done in that aspect, Your Honor, but I assume...
So you are assuming the facts of this case?
No, Your Honor.
That there are, in most
question is
cases, in all cases, as a matter of fact, that it is the legislator that gives final say.
No, Your Honor. We are looking at the law itself.
And probably when the respondents take their turn, perhaps they can take a look at the expenditure of the DBM and show to us whether there are instances where, from the Pdaf, there were expenditures. Would that be fair?
They can take a look at that. That's their prerogative, Your Honor. But we are
Yes.
confining ourselves on what the law actually says.
So
Your
just looking at Section 2, can we do a facial challenge or judge the constitutionality of Section 2 simply on the basis of the words of Section 2?
I submit, Your Honor, yes.
For that matter, are you aware if there are priority lists submitted by the implementing agencies, not the menu, but a priority list submitted by the agencies to Congress?
Your Honor, if presuming from the fact that the government has already indicated that they in fact created the DAP, there was already
Counsel,
SARS.
this is a factual query.
Yes, Your Honor.
Are you aware of any priority list?
Personally, Your Honor, no.
And you want the provision attacked on the basis of facts which have not yet been established?
We want the provision attacked, Your Honor, not on the basis of facts that
But
have not
perhaps
been
in your
established.
memoranda, you can tackle the issue as to whether Section 2, which tackles project identification, involves identification by the executive or identification by the member of Congress. And there are two parts here. First, whether the priority list is specific enough, as in kilometer number to kilometer number for purposes of farm-to-market roads. And second, whether in fact there has been actually disbursements without the concurrence or despite the concurrence or recommendation of a member of the House and the Senate. But that nonetheless, Counsel, if Section 2 is declared as unconstitutional, do we have to declare the entire Title 44 as unconstitutional? If Section 2, special provision, is declared as unconstitutional, do we have to declare the entire item?
No, Your
Maybe
Honor.
I should lay the premise. Were there general appropriations acts which did not contain the special provisions that we have now in 2013?
Yes, Your Honor.
Yes. So is it possible that we declare the special provisions as unconstitutional and still remain with Section 1 of Title 44, which, by the way, will look like what we tackled in the case of Philconsa versus Enriquez?
The CDF formulation.
Yes,
Your
the CDF formulation.
Yes, Your Honor.
So it's possible.
Well, that could be possible, Your Honor, but it is our position that it's the entire provision, Title 4.
But you have jurisprudence which actually says that if there is a difference first between an item and a provision. This is Gonzales versus Macaraig, among others. And that, of course, a provision cannot be vetoed by the President, it is the entire item that should be vetoed. However, there is a qualifier to that. If it is an improper provision, then a veto of that provision is valid. Is that not correct?
Yes, Your Honor.
And in that light, by analogy, we can declare some of the provisions as unconstitutional.
Yes, Your Honor.
Unless you have reasons for the entire item to be declared as unconstitutional.
We are declaring that in our petition, Your Honor, but to further elucidate on that matter, we will include it in the memorandum. Your Honor.
Please do, because I think that it is important that we should dot the I's and cross the T's,
yes,
in order that we can provide clearer guidance to members of the House and the Senate.
Yes, Your
So
Honor.
your position is that the House members and the Senate members cannot implement any project.
Yes, Your Honor.
Can they recommend to the executive the execution of a project?
Just recommend, Your Honor.
Yes. I mean, can a senator call the President of the Republic of the Philippines and tell the President, please, we need a bridge
Yes,
that
Your
will connect two of our islands? Can they do that recommendation?
Yes, Your Honor.
Isn't that what is in the Pdaf now?
Your Honor, no.
Can we make a distinction between that kind of a recommendation, which does not seem to be worded in the Pdaf now, the political recommendation, and a recommendation that is clearly from the provisions?
Yes, Your Honor, we can.
In your memoranda?
Yes, Your Honor.
Or is it that we are attacking the Pdaf title on the basis of actual practice?
We are using the COA report, Your Honor, guided by the previous LAMP decision.
Again,
Your
the COA report covered current year 2007 to 2009. And you're using it as factual base to attack the General
2000.
Appropriations Act of 2013. Why is that?
Your Honor, it is our allegation. There's a pattern. It's a system
Pattern
that we're
for
talking about.
2007, 2008, and 2009, correct? 3 years.
Yes, Your Honor.
How long has the pork barrel system been in place?
From 1994, as far as I recall, Your Honor.
Meaning to say how many years?
17?
17 years that we had the pork barrel.
Yes, Your Honor.
And you have a COA report that actually covers only 3 years.
Yes, Your Honor.
And it is representative of the 19.
Yes, Your Honor.
Because?
Yes, Your Honor. Because even the COA commissioner herself, Your Honor, indicated earlier while she was testifying.
What is the
that there's a
binding
pattern.
nature of the statement of the COA commissioner in terms of facts in a court of law?
Your Honor, it is testimony made by the head of a
Again, we
government
just want
agency.
to dot the I's and cross the T's. This is in no way reflective of how we are going to decide in the case, but we do need to have more particularity in terms of the pleadings and the memoranda that you submit, and perhaps you can cover this. For that matter, the COA report, does it establish facts absolutely? Or is it simply a finding of our auditors, our constitutional auditors, as to a state of affairs?
It is a finding of our constitutional organ mandated, Your Honor, to
Are you
investigate
aware
facts.
of cases that we have decided? The most recent one is in April 13 of this 11 of this year, penned by the Chief Justice herself. Title of the case is Special Audit Team versus GSIS, where the Supreme Court held en banc without any dissents that a report or an initial report of the Commission on Audit to attack that is premature because there are levels of actually determining the facts that it alleges in the COA report. In other words, there is still a notice of disallowance, there is still a contesting of the disallowance, there is the judicial review of that contestation of the allowance until it reaches the court.
I have not come across this case, Your Honor, but we will address it in the memorandum. However, Your Honor, if I may vouch an opinion with respect to the question, I believe, Your Honor, that judicial power of this honorable court is not confined to situations where the facts upon which a constitutionality of a law are only proven to the level of exactitude of the rules of evidence.
But we have to provide guidance because, as you said a while ago, do the Pdaf provisions become stricter and stricter as the years go by?
It appears so, Your Honor.
Yes, and as a matter of fact, the strictest that we have had so far are the special provisions in 2013, along with the general provisions that are contained in this particular law. For instance, are you aware of the time limit for the expenditure of an item under the GAA, which includes the Pdaf, under the General Appropriations Act?
Time limit, Your Honor.
The first provision in the General Provisions actually says that they are only applicable for the 2013 current year. Is that not correct?
Yes,
and for
Your Honor.
that reason, members of this court that appeared for the budget hearing in the House and the Senate are being pressured by the House and the Senate to actually commit that we are going to decide this year. Is that not correct?
I've heard of that incident,
Because
Your
in the
Honor.
past years, there can be continuing appropriation of the Pdaf. Is that not correct?
Yes, Your Honor.
And therefore, there are stricter measures now in terms of the current budget. Is that not correct?
Yes, Your Honor.
And therefore, we have to be very clear about the specifics of our decision so that we can avoid the constitutional evils that you have identified.
Yes, Your Honor.
Okay. If we remove the discretion from the members of the House of Representatives to identify a local project, then who will take care of the local constituents?
There's still the executive, Your Honor. We still have the LGUs, Your Honor.
The local government units. By the way, can the local government units themselves have pork barrel?
I believe, Your Honor, it is possible, Your Honor.
But is that covered by your petition?
No, Your Honor.
Because in some of your petitions, the attack seems to be the pork barrel system. And we are not clear which provisions you are attacking. In fact, in your petition, the Belgica petition, you did not mention any specific provision in the General Appropriations Act or the special provisions or the general provisions that you want to declare as unconstitutional. All it says is the pork barrel system.
I believe, Your Honor,
And perhaps you can become more specific and
We will, Your
detailed because there is also pork barrel in the local government units, and I am sure that your pleadings did not attend to that provision. Given the fact that there are local government units with budgets and ERA that are provided to them, don't you think that the Pdaf, because it is exercised by national officers, affects local autonomy?
Yes, Your Honor.
Is it your position that it violates local autonomy because the member of the House participates in the implementation of projects?
Your Honor, our position, Your Honor, is that it shifts the burden and the sources of funds, Your Honor, away from the constitutionally mandated
Or does it
focus.
depend, or does it really depend on whether the member of the House or the mayor, for that matter, are friends or allies?
Well, yes, Your Honor.
Can we say for certain that it violates the local autonomy provisions then, without facts?
Phrased that way, Your Honor.
Again, perhaps you can cover this in your memoranda. The TRO merited a DBM circular. Are you aware of the DBM circular?
No, Your Honor.
Issued September 27, 2013. And part of your argument was that we do not lift the TRO. Are you aware of the contents of the DBM circular?
Unfortunately, no, Your Honor.
The DBM secretary distinguishes between SAROs which are obligated and not obligated. Our TRO says no release. However, there is a distinction between SAROs which are obligated, which means that they can get an NCA and have it released physically, and those that are not obligated, according to the DBM circular. Do you think that this follows our temporary restraining order?
Your Honor, the temporary restraining order is unfortunately is phrased as no release.
Release.
Yes, Your Honor.
In other words, what is the concept of release? When a SARO, an allotment release order, is issued, can we not consider that as having been already released
Yes,
prior to the TRO?
If there's no NCA, Your Honor, there's no obligation yet.
And your legal basis for this is?
Your Honor, from my understanding of the DBM procedure.
Oh, can we proceed on the understanding of counsel, or should we have a law
Yes,
or
Your
an implementing regulation, or perhaps the
Yes, Your
GAM
Honor.
that actually points out to whether or not the interpretation of the DBM secretary is correct?
Yes, Your Honor.
And for that purpose, then there can be SAROs which have been issued that have been obligated for college scholars and, for that matter, medical needs of indigent patients that can still be paid for if the DBM circular is correct. And for that purpose, we do not need to even amend our TRO. Is that not correct?
Yes, Your Honor.
And the DBM Secretary's interpretation will therefore address the concerns of some members of the House and the Senate or that of the respondents. Is that not correct?
Yes, Your Honor.
If it is correct, Counsel, is that not right? Okay. Counsel, would you know the budget of the judiciary? The entire judiciary.
The entire judiciary, Your Honor.
If I'm not mistaken, it is 18 billion. 18 billion. Counsel, can you tell us how much in terms of Pdaf have we stopped? I'm sorry. Can you tell us how much the entire Pdaf lump sum item is, that special purpose fund?
It's around 24 billion, Your Honor.
24 billion for the Pdaf.
For Pdaf, Your Honor.
Yes.
This year.
Yes. Title 44 is 24 billion. Yes. It is just one title that affects the legislature and the executive. Is that not correct?
Yes, Your Honor.
Yet for the entire judiciary, this is from the Supreme Court down to the Metropolitan Trial Courts, the entire budget of the judiciary is only 18 billion. Is that not correct?
Yes, Your Honor.
Do you know how much it requires for each of our trial courts to have only one coterminous legal researcher each?
I am not aware how much.
1.4 billion. Is that not correct? 1.4 billion. And the Pdaf item that we have stopped is 14 billion. Is that not correct?
Your Honor, yes.
Let me ask you a question that was raised to us in the budget hearing. Can the President realign the budget of the Pdaf and give it to the judiciary?
Your Honor, I submit no.
Because?
Because, Your Honor, that would
of
be
the
a transfer.
constitutional prohibition that only the Chief Justice,
Yes, Your
only the Chief Justice can move savings within the judiciary.
That's
So for that matter, for the rest of the 2013, none of our lower courts have coterminous legal researchers. And only the judge is actually making the decision. Is that not correct?
It would appear that way, Your Honor.
Of course,
yes.
that is not in your pleading.
Yes, Your Honor.
Yes, it's just an observation. Next, counsel, can we implead the President before the Supreme Court? Can they be impleaded as respondents? Can the President be impleaded?
As a technical matter, Your Honor, we don't.
But your petitions, UDK, the UDK case impledes the President.
Yes, Your Honor.
In any case, perhaps counsel for that petition can explain why we should not dismiss that petition outright, in the sense that for reasons that the President is impleaded, unless one can find exceptions to that.
Yes,
May
Your
I
Honor.
call on Attorney D to answer the last few questions. It will be very brief. Attorney D, are you familiar with Section 29 of Article 6 of the Constitution?
Yes, Your Honor.
In your presentation, you read out to us the first paragraph, number 1. No money shall be paid out of the Treasury except in pursuance of an appropriation made by law. Is that not correct?
Yes, Your Honor.
Yes. But it is actually 3 numbers. And there is number 3. Can you please read number 3? Section 29.
Your Honor, Section 29, Paragraph 3 provides, all money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only.
So the Constitution allows a special fund to be created different from the General Appropriations Fund. Is that not correct?
Yes, Your Honor.
And that special fund can be created by law.
Yes, Your Honor.
Yes. Because in your presentation, you said that all expenditures coming from revenues should be appropriated by Congress through the General Appropriations Act. Or was I mistaken in terms of understanding your presentation?
That is correct, Your Honor.
But in spite of Section 3, number 3 of Section 29, the Constitution allows the creation by law of a special fund. like Presidential Decree 910 creates a special fund.
Yes, Your Honor.
Just so we are enlightened, can you distinguish for us a special purpose fund from a special fund?
Your Honor, a special fund under Article 6, Section 29(3) is created, is sourced from money collected from tax, Your Honor. While a special purpose fund is not necessarily limited.
A tax that has a special levy.
Yes, Your Honor.
Such as, for instance, fees of service contractors in the case of Presidential Decree 910, correct? And the law actually levies those fees for the purpose of creating a fund called the Malampaya Fund, and so on and so forth.
As I understand the PD10, Your Honor, it's not limited to fees, Your Honor, but revenues, Your Honor.
So it is possible to have a law, a revenue bill, that has a provision which actually pertains to how the funds that are collected or levied are going to be spent.
It
is not unconstitutional simply because it is not in the General Appropriations Act.
Well,
and number 3 of Section 29 only says that if there are unexpended amounts or if the purpose is abandoned, only then can that portion be included in the General Appropriations Act.
It states so, Your Honor.
Or perhaps you can again cover this more clearly in terms of the your memoranda.
We will
For
do so.
the special fund that are created, what is the requirement in terms of the statement of purpose?
Your Honor, the statement of purpose must be specific, Your Honor, such that there's no room for the executive to impose his discretion, Your Honor.
Where does it say specific purpose? In number 3?
It doesn't say, Your Honor, but nonetheless, Your Honor, it should specify. Otherwise, the President can state whatever purpose, can use the fund for whatever purpose if it is not specific.
But if
Your
that
Honor.
is allowed by Section 29, Paragraph 3, then isn't that part of the constitutional order as much as unlawful delegation of legislative power? The power to appropriate is granted to Congress as a check on the President.
Yes, Your Honor.
And the power to appropriate is defined in several sections in the Constitution.
Yes, Your Honor.
And this is one of it. Is that not correct?
It is one of those, Your
Isn't
Honor.
this a provision in the Constitution which loosely gives Congress the power to give the President carte blanche authority with respect to a special levy?
I cannot agree to that, Your Honor.
And what in the text helps us determine that?
Your Honor, I would consider the fact that you also have to consider the fact that PD10 is also a discretionary fund, Your Honor. And under Section 25, Paragraph 6, Section 25, Paragraph 6 of Article 6, it provides that discretionary funds shall be dispersed only for public purposes, Your Honor.
For public purposes?
Yes, Your Honor.
Only for public purposes, not private purposes, correct?
Yes, Your Honor.
Does it say a specific public purpose?
Your Honor, the provision also provides that it must be subject to guidelines prescribed by law, Your Honor.
And if there are specific guidelines
then
which
it is,
allows the expenditure for whatever the President wants?
Then, if there are specific guidelines, Your Honor, then it complies with the requirements under the Constitution.
Actually, it says, and subject to such guidelines as may be prescribed by law. Is that not correct?
Yes, it states so.
It doesn't say specific.
It says guidelines as may be
Again,
prescribed.
this does not necessarily reflect on how we are going to rule on the case, but perhaps you can cover these provisions when you submit your memoranda. I am just concerned that you overly focus on only one part of the Constitution without actually looking at all the parts of the Constitution.
Yes, Your Honor.
Yes.
We will do though. We will do that.
I have no further questions, Chief.
Just
Thank you,
one
Counsel.
question from Justice De Castro and then Justice Reyes.
Can I ask Chairman Pulido to please answer this question? Just one question for Chairman Pulido. As a friend of the court and for the record, will you explain to us how the PDF is disbursed up to the time that it reaches an NGO? Will you also tell us how an NGO is chosen?
Your Honor, I described earlier the general flow of release of the funds by the DBM, and that is prompted by a request or a letter of a proponent legislator to the Appropriations Committee of the lower house or the Finance Committee in the case of the Senate, requesting for the funds. And then this is transmitted by the Senate President and or the Speaker of the House to the DBM, on the basis of which the DBM issues the SARO and subsequently the NCA. The funds are released by the DBM directly to the implementing agency. We did not find any instance when the DBM released the funds to any of the proponent legislators. However, in the hands of the implementing agency, soon after the SARO is released, we found letters from the proponent legislators to the heads of the implementing agency, advising them generally that a SARO has been issued and that they desire a SARO has been issued allocating to them a certain portion of their Pdaf entitlement, and that the legislator desires that this money be used for a certain project, and that a certain NGO is specified in the letter to be the partner in the implementation of this project. That is the general tenor, Your Honor, of letters that we have found in the course of our audit. And invariably, the heads of agencies would get in touch with the NGO, and then there is contact between the agency and the NGO. Certain documents are arranged to be executed between them, basically the memorandum of agreement, and soon after we find that the Pdaf allocation of the proponent legislator that was released by the DBM to the implementing agency is soon transferred to the NGO. However, the implementing agency would normally retain a certain portion of the funds, on the average about 3% as management fee. So that is how the process that we have found and which we have documented goes, Your Honor.
So there's no bidding at all?
No.
No bidding in the choice of the NGO?
No bidding, Your Honor, and that is precisely one of one of the findings, one of the more significant findings that we had. Not only that there is no bidding, but also under existing guidelines, Your Honor, for example, the implementing rules and regulations of the Procurement Act, RA 9184, in fact provides that an NGO and an implementing agency may enter into a memorandum of agreement for the implementation of a project when there is an appropriation or ordinance that specifically earmarks or authorizes the contracting out of a specific amount to such NGO. And we found, Your Honors, that there was no such appropriation or ordinance. Nonetheless, the implementing agencies transferred the funds to NGOs that were identified and endorsed by the legislators, and that also, even assuming that there would have been such an appropriation or ordinance, still the requirements of the procurement law and its implementing regulations that the selection of the NGO should be done through public bidding or negotiated procurement should have been followed. But again, these were not followed. And the RA 9184 and the implementing regulations also require that in any case, whether an NGO is selected on the basis of a bid or a negotiated procurement, there has to be a performance bond at the very least and a warranty.
Are any performance bond posted by the NGOs?
None at all, Your
None?
Honor.
And where do they get the names of these NGOs? Is there any system of accreditation or anything like that?
The NGOs were chosen on the basis of what the legislators asked them, put in their letters. So they were nominated by the NGOs, and the implementing agencies invariably just acceded to this direction and instruction from the NGOs. Again, Your Honor, the implementing regulations of RA 9184 as well as circulars require or designate the Bids and Awards Committee of an implementing agency to act as the selection processor. The job of the BAC in this case would be to screen and evaluate the required documents, and as well as to make an assessment of the technical capability, financial and technical capabilities of these NGOs. But we did not find this procedure or requirement to have been complied with, Your Honor.
Okay, I just want...
Justice.
Okay, Justice Brion.
Just a couple of questions to the Madam Chair of the COA. Madam Chair, you came out with a COA report on the DAP. And at pages 23 to 25, 23 and 24,
Yes, Your Honor.
of the report, you have a lot of recommendations, right? And in these recommendations, you noted a lot of deficiencies that should be remedied for purposes of compliance with the laws and the rules, applicable laws and the rules.
Yes, Your Honor.
As a matter of, as a general proposition, in case there are deficiencies, can this be the basis for criminal liability on the part, for example, of the acting, the officials of the DBM or the implementing agencies who are acting on these matters?
Yes, Your Honor. As a matter of procedure, we refer to the Ombudsman reports of this nature for further evaluation further evaluation of the Ombudsman for possible criminal violations and the filing of appropriate charges if so warranted. Because on the part of the Commission on Audit, our charter only limits us to exacting some kind of a civil restitution. Yes, Your Honor, and this is effected by way of the issuances of a notice of disallowance, where in effect we are asking those involved in a particular transaction to restore the money which we found to have been irregularly or illegally dispersed to return, Your Honor.
And this would fall perhaps generally under Republic Act 3019.
Yes, Your Honor, and also 6713.
Can you give us, can you submit to us a list of those whom you have recommended for the filing of charges?
Your Honor, if
based on this COA report.
Yes, Your Honor. Effectively, Your Honor, everyone who has been named in this report has been forwarded to the Ombudsman.
Have you finished your audit of the Office of the President for year 2011?
Yes, Your Honor.
and for year 2012.
Yes, Your Honor.
Can you submit to this court a copy of your report on the Office of the President? My interest is...
Your Honor, our audit of the Malampaya funds is not contained in our audit report of the Office of the President. It is the Presidential Social Fund.
Presidential
that is
Social
in there.
Fund.
Our audit of the Malampaya funds would be found in each of the agencies that received amounts from this fund. But right now, we are in the process of auditing, coming out with one consolidated report affecting all the agencies. And as of today, as of August, Your Honor, the total releases from the fund has reached about 38 billion to about 15 to 20 government agencies, and that is the subject matter of the audit that is ongoing, Your Honor.
Would it be possible for you to extract from the finished reports on these agencies those portions referring to the Malampaya Fund and submit this to this court?
Yes, Your Honor.
So these extracts plus the COA report on the Office of the President for 2011 and for 2012.
Yes, Your Honor.
Thank you very much.
Thank you, Your Honor.
Justice Bersamin.
Thank you, Chief. Chairman Pulido Tan.